work. Thus, the President has ended affirmative action in the United States of America. At this time,
oh, apologies.
what the bill says, because after reading the bill, I think you will all agree that, in the Declaration of Independence in the United States of America, all people are treated equally. All people are treated equally, and so that's what we need to return to. We need to focus on those in critical needs areas, and that's what I love the most about this bill, is that we're focusing on critical needs areas. No matter what the color, the race, or the sex of that person, we want to make sure that all critical needs are covered, and that's what the bill focuses on, critical needs in our state. And I would say it does not end any program. It expands every program to make sure all those that are critical needs areas can be addressed. So we'll start out just with the first. I'll read the very beginning of Section 1. The intent of this legislation is that the General Assembly intends for this act to prohibit discrimination by public entities on the basis of race, sex, color, ethnicity, or national origin. The General Assembly does not intend for this act to affect any preferences provided to veterans under the law based on their status as a veteran. So it's very important that last time when we ran this bill, we did not have that in there. So make sure that veterans are not covered, or not affected by this bill. Okay, so if we look there, the rest of sections 2 and 3, we're really just getting rid of equity and replacing it with equality. Again, in the United States of America and now in the state of Arkansas, we're going to treat people equally. Everybody treated equally. So as you can see, civil rights is crossed out and it's replaced with desegregation and non-discrimination throughout that section. Okay, Section 4, we're just crossing out again anything that was with affirmative action and treating people unequally. That's what gets rid of in Section 3, Section 4, and 5 throughout there. We're just removing affirmative action in Arkansas. Section 6, it gets rid of the Arkansas Higher Education Annual Report. Section 7 gets rid of the Higher Education Minority Retention Program. Section 8 removes affirmative action programs. Now into Section 9. Again, we have replaced minority with critical needs. I know that in my district alone, I have high areas of Hispanics, Black students, all race of students, white students that are really in critical needs areas that need special help. And so we're replacing that with critical needs so we can focus our attention in the state of Arkansas where it needs to be on critical needs. Same with Section 11 and growing through there. So I want to, on page 11, we'll look at Section 21. Prohibition of discrimination or preferential treatment by state entities. As used in this section, state means the state of Arkansas, a city, a county, or an institution of higher education, a public school district, a public school district, a public special school district, or a political subdivision or governmental instrument of the state. The state shall not discriminate against or grant preferential treatment to an individual or a group on the basis of race, sex, color, ethnicity, or national origin in matters of state employment, public education, or state procurement. This section applies only to an action taken after the effective date of this act. So it does not go backwards. It just goes forward. It moves Arkansas forward. So again, it's really important. This section does not, this again on page 11, this section does not prohibit this consideration by the state of bona fide qualifications based on sex that are reasonable and necessary to the normal function of state employment, public education, or state procurement. Number 2, this section does not invalidate a court order or consent decree that is in force as of the effective date of this act. And this section does not prohibit an action necessary to establish or maintain eligibility for a federal program if ineligibility would demonstrably result in a loss of federal funds to the state. Again, affect any preference given to veterans in matters of state employment, public education, or state procurement, or preempt the state discrimination law or federal discrimination law. And then very importantly, if a person believes his or her rights have been impacted under this section, they may bring a civil cause of action in circuit court to enjoin a violation of this section, recover reasonable court costs and attorney's fees. And an action brought against this section, if the court finds that a violation occurred, the court shall award an injunctive relief and court costs. So that pretty much goes over, and the rest of it's just making sure that our state agencies report to this body on how they're complying with this law. Okay, friends, that pretty much goes over the law, and I will take questions from members of the committee.
Thank you, Representative Bentley. Representative Bentley has explained her bill. Are there any questions by the committee? Representative Ennett, you're recognized for a question.
Thank you, Chairman Gasway. Representative Bentley, I've sat through the Senate committee and I also watched the debate on the Senate floor, and I just listened to your presentation, and I did not hear any type of statistical information showing that this is harmful, that this harmfully impacts Arkansans here. Can you speak to that?
This is strictly lining up with federal, what's going on the federal level to get rid of affirmative action. I know ample instances of people across my district that have reported that they have been negatively impacted by our current laws that we have in place. With and school enrollment, scholarships, multiple things over the years that I've been in here. I have my constituents are firmly in favor of SB 3.
Okay. Chair, can I have leeway? Can I ask another question?
Of course, go ahead.
Okay. So I know maternal mortality is your one of the things that you're working on here in Arkansas. African American women in Arkansas are disproportionately, our numbers are higher. If this bill goes into effect, how would this help efforts in solving the maternal mortality issue with African Americans here in Arkansas?
Well, I think this bill, again, it focuses on critical needs, but I'm having a bill on the House floor today that will help get certified nurse midwives in our state. Arkansas has been the most restrictive state in the nation for certified nurse midwives. We have not allowed certified nurse midwives to practice. And in states across the nation where they have high rates of minorities that are struggling with maternal mortality, they have implemented certified nurse midwives and seen a huge traumatic effect, and so a positive effect. So that's one of the biggest things that I've seen. So I have been to numerous conferences to see what can we do with maternal health here in Arkansas, and we are moving in the right direction. I'm very excited about the things that we do in this session. So that bill on the House floor,
we want the free market to fix the problem,
that.
not
So again,
programs.
we're focusing on where are critical needs in the state, regardless of someone's color or their race. We want to make sure that we get critical need areas addressed. And I have one of the biggest awards I got was my from the Maternal Health Commission for being a legislative award. I have worked diligently to make sure that we address those needs across our state, and we want to focus them. I think we will be able to focus those areas of critical need wherever they are in the state.
Thank you.
Representative Ennett, do you have more questions? Okay, all right. Representative Cloudy, you're recognized.
Thank you, Mr. Chair. Representative Bentley, you mentioned, I think it was when you were reading the statement at the beginning, that programs like the ones that you're seeking to eliminate work against the values of hard work, determination, those kinds of things. I'm sorry, I'm probably butchering the quote, but I think you know what I'm referring to. I guess my question is, could you say a little bit more about how retention and recruitment programs that are aimed to help traditionally underrepresented populations, particularly when we are looking to mirror the populations that they serve, say in a school district, how do those programs undermine hard work?
I think every child in Arkansas deserves the best and the brightest, and we need to base things on merit. I want the best person there for those kids. It shouldn't matter what the color of their skin are. What should matter is that they're getting the best and the brightest in those positions, and we're addressing those areas of critical need. I think that we've seen that on the national level. What the president was talking about was the recent crash we had of the helicopter pilot that was not trained and should not have been flying as she was there. I mean, that's all under investigation now, but we need the best and the brightest. We don't need someone based on what the color of their skin are. Every child in Arkansas should have the best they can get for a teacher that's in their environment. And I think that's what it's based on. We want it all based on merit and on hard work. And that's what those kids need to see.
Thank you. And I certainly agree that all of Arkansas's kids deserve the best and the brightest. I'm thinking of school districts like ours in Northwest Arkansas, where there may be a need for, say, something like a Marshallese liaison or a Latino liaison between students and faculty, between families and staff and teachers. When we are looking at creating a pool of folks who are going to be best at that job, when we are looking at doing recruiting for those jobs, I'm having a very hard time understanding how recruiting based on in those instances, if we wanted to base it on national origin as something that would be helpful, right? We want to create a pool of folks who are going to be able to do this work. I just don't understand why that undermines hard work. And it actually seems like we are going into communities and encouraging hard work. We are asking folks to step up and do these roles. And I guess my fear is there are certain jobs where I believe that, in fact, national origin, for instance, is critical to your ability to do the job. We are, with this bill, undermining school districts' potential to even consider that or to give anybody preferential treatment based on what I think would be considered a critical component of their ability to do that job. And I guess that's kind of my question for you is, how do retention efforts that are based on specific things like that undermine hard work?
I think, again, I'm going to go back to the statement that our kids need the best and the brightest. If there's a person that's qualified, that is able to translate, why would we care what color their skin is? We want the people that can translate and reach those children the best. I think we want the best. And I'm just referring back to that. I think, this is not something new. Our nation has been a nation of immigrants from its beginning. We're looking back at the what was done to the Irish folks back in New York City. I hope that all of you have seen the movie Cabrini and talked about what they did with the Irish kids back there and the kids that were mistreated. And we've had this across our nation. We want the best and the brightest. I don't care what somebody's skin color is or where they come from or where they're born. Our kids deserve the best. And if that person can translate, I think that's what the school can look at. It's not going to undermine anybody. If they're doing a great job, they can be hired, and that's what it's about. And this is the United States of America. Everybody should be treated equally, and that's what I want us to do.
Thank you. And I certainly agree with that. I guess sort of switching to maybe gender as a different example, can you just explain how you see this bill impacting gender-specific programs? I'm thinking about things like Girls on the Run, or My Girls Do a Girls in STEM program at their school. How do you see this? Providing those programs, I think, is ipso facto giving preferential treatment based on gender. How are those programs going to be impacted moving forward if this bill goes through?
I don't see the impacting things that we're doing with girls in STEM. I think that we can still continue to do that. We're not stopping girls' sports, but this bill doesn't stop girls' sports. It doesn't stop things that we're doing there. And I can tell you, I think the best thing to differentiate, that was our former colleague, Deborah Ferguson. I'm sure you remember her speech on the House floor when she was actually opposing this bill. But she said when she was as same age as I was back in the early 1980s, when she went to dental school, there were 5 girls in her class. Now, last year, there was 50% of them were girls. So I think we've seen a great stride of women moving forward. And I think, again, we're all on an equal playing base. We don't need anybody to be the victim. We all need to strive and to work hard. And as a woman of my own business, I can understand it's tough, but I have worked hard. I worked hard, and we have a place that we're going to reach out and reach those critical needs areas. If we're all focusing on where critical needs areas are, we can bring all of our state up, and that's what I want to do.
Just one last question, Mr. Chair. Thank you. One last question, and then I will cede to somebody else. But I think everybody at this table appreciates the value of hard work. We wouldn't be here if we didn't do it and appreciate it. But I also think we all at this table can appreciate the value of having programs that are aimed towards specifically our young girls. I know that there are really important programs right now that are looking at getting girls more involved in science fields, technology fields, maybe thinking about starting entrepreneurship skills at a young age. Girls on the Run isn't a sport. It's technically considered a club. I appreciate what you're saying, but I just want to go back to the language of the bill. That is providing those resources for clubs like that, for groups like that, is preferential treatment based on gender. Can you point me to somewhere in this bill that shows me, that would give me some confidence that those types of groups would be allowed to continue to exist?
I would say that the women in that area need to rise up and give some money and help donate. If it's important, a cause for a club, then reach out to some very substantial women in your area, let them be mentors and let them donate to the club. I think we look for the government for the answer for everything, and it's not. We need women to rise up and to be mentors and to be mentors for those young girls. I mean, I would just start a program in Mayflower where we're reaching out to women and to come and to be mentors and to be moms in the school. I think we need to reach out and bring our community and let that be the answer. Nothing in this bill would stop that.
Representative Hawk, you're recognized. Okay. All right. Representative Collins, you're recognized.
Thank you, Mr. Chair. Representative Bentley, you talk about wanting the best and the brightest to do things in our
So the
society, and I
Democrats
think
are going to
we
keep
agree with
whining
that.
about
I
this.
think
They're going to
most
keep
everybody agrees
saying
with that
ending
merit
DEI will
should
somehow
be the priority. What about
harm the effort
opportunity,
to get
though?
the right
Because, I
people,
mean,
but
it's very clear, and I don't
not
think that
true.
you would disagree
Folks,
with
I'm going
this,
to go
although if
ahead
you do, please
and
let me know. That
take
there are
off,
some
take it
people
off
who
a
are
little bit.
represented
I'll
traditionally
watch
or
this. We'll
otherwise
do
in
a
certain
broadcast
fields
at
and in
12:35.
certain
I'll talk
places,
about this and a few other
and
issues
they
going on.
don't have the opportunity oftentimes to show their merit. For example, women in engineering, they're traditionally underrepresented there. So if we get rid of scholarship programs that or support women in engineering, then a woman who is very bright, is very able, has merit, might not never have the opportunity to show that merit and demonstrate that in the field of engineering. And I think a lot of these programs that we're talking about simply doing away with are designed to increase opportunity. And then they would have the opportunity to show that they have merit and continue in their career and demonstrate that accordingly. So what do you think about that argument that, in fact, this is not supporting merit and this is anti-merit to take away these opportunities for people traditionally underrepresented?
I think we have a female governor for the first time ever in this state, and it shows that women are moving forward and women don't need preferential treatment. I'm sorry, I find that very insulting. I apologize.
Okay. Why do you think that the governor talks about being the first woman governor? Why do you think that matters, or do you think that matters?
I think it's great. I'm very excited that I was the first woman ever elected in my district. I was the first Republican woman ever elected in my district. I think it's great. I don't know very many other business owners in my state or in my district, but you know what I do? I reach out. I help young girls. I encourage young girls to be a page here all the days. That's reaching out, being mentors, and reaching out and doing things. It's not always the government program to fix things. It's us reaching out as a community and being mentors and reaching out to women in our area. So again, we want the best and the brightest, and strong women can do great things, and that's what I'm telling you. We're in a day and age where companies are looking and wanting women, not just because they're women, because they see the value that women bring to business. Women have a different perspective. Women bring great value, and we don't need to be victims, and we don't need preferential treatment to get where we need to be.
I think it's great, too. I think it's great that you were the first representative who was a woman from your district, and I think it's great that the governor is the first woman governor. But I also think it makes my point is that women have been traditionally underrepresented in a great many areas over the years, and it is difficult. And I don't think that a program like this that encourages opportunity is something that we should reject. I don't think it's something that we should pretend is not an issue. There are people underrepresented from different minority groups, including women, in many different fields. And I just think that your experience and the governor's experience just drives home that point.
I would agree to disagree with you. Thank you.
Representative Wardlaw, did you have a question? Okay. Representative Mayberry, you're recognized.
Thank you, Mr. Chair. So as Representative Ray reminded all of us yesterday, read the bill. I have read the bill in the past, looked over it, because I was asking you some questions about it. So that this was not my first look at it today. But at 4 o'clock this morning, I was up and I was reading it again. And I was noticing on page 3, it makes reference to this teacher and administrator recruitment and retention plan, and it said that there's a report due by August of 22. And I went, oh, okay, that must mean that we must have been in this recently by law, in a previous session, because we've updated it. So I went back and I found, sure enough, Act 646 of 2021. It was a bill that was brought by Senator Sturch and Representative Vaught, and it passed the Senate 34 votes and the House 85 votes. So I voted for this bill in this language that is being completely stricken out in page 3, 4, and 5 back in 2021. So I went, okay, what were we doing back then? And then what are we trying to do now? And what has changed? So I've gone on record back in 2021 that I support this language. So help me and other legislators understand maybe some other things that have happened since 2021, maybe even a Supreme Court decision that helps us move the bar from where we stood in 2021 to now. Help us get there. I'm looking for some support and some help in getting from 2021 to now.
Oh, Representative Mayor, I'm sorry, I don't have that information for you. Senator Sullivan is sick in bed, or maybe he would be able to help us with that. But I can get it back with you before we vote on the floor. But I don't have an answer to that question. I know that we're, and I have not heard any objections from this from Secretary Lee. And I'm sure if there was an issue that he would have reached out to me to make sure that I knew that there was an issue. But obviously, there's not an issue there. I've not heard an issue from the governor's office on this. So obviously, there's not an issue at this point. So I'm sure you can reach out to them and verify that.
Okay. I just was looking at it. It's a lot of reporting. It's not so much the, you're going to hire this person over this person in that language. It's a lot of reporting from the school districts and the universities. And so I was just kind of wondering, maybe we've heard that this reporting is very cumbersome. It refers to hiring a part-time to a full-time person in that language. And, maybe this helps save some money. Maybe that money could be used to do something else. Is it a cumbersome thing, the reporting?
I'm sure that it is, but I would have to reach out to Secretary Lee and get back with you to verify that, because I've not talked to him specifically, so I would not want to put any words in his mouth. But I know that other legislation that I've passed for farm to school and for local foods bill has been a very cumbersome report, and we're trying to make that simplified. So it very well could be that's been unnecessary, so a heavy burden for our districts. But I'm not going to say that without talking to him specifically, and I apologize. If I'd had time enough, I would have definitely reached out to him this morning, but I wasn't given that chance.
I'm sorry. Again, this kind of all happened this morning. I was trying to gather my information as well, but
if I had a phone call at 8 o'clock this morning, I could have had an answer for you, but I don't. Thank you.
Representative Wardlaw, you're recognized.
Representative Bentley, I'm sitting here and kind of look retarded with two of these iPads, but I was trying to see from the bill last session to the bill this session, what was the big differences? Can you walk me through the differences? Because the bills are not similar at all to what I can see. So can you walk me through what this bill does different than the bill that was proposed 2 years ago?
I cannot.
You cannot?
I was not the lead sponsor when Senator Sullivan brought that before. That was Representative Gonzalez, and it's been 2 years, and I've not looked at the last bill. I have studied the bill that I'm presenting to you today. I do know that we're making sure that veterans are not included in this, because we did, that was an issue last time.
Veterans, last time,
and they were included last time. And also there was a criminal penalty, and that criminal penalty was taken out of this based on some issues that Senator Hager brought to me, and I made that amendment before we brought the bill to you today. But I apologize, I was not the lead sponsor on it. Representative Ward, also I cannot tell you. I've just studied SB3, so I'd be prepared for today. I'm sorry.
So if you follow me in your bill to page 12, Mr. Chair, if I could have some latitude.
You're recognized, of course.
Line 15, it goes into injunctive relief, and it talks about the court costs and attorney fees. And if you could kind of explain to me what line 17 through 19 actually means. It says if the court may not award court costs, then are you saying that they can go to the Claims Commission to get their attorney fees back if they lose? Or what does that mean, that section?
They may go to. Doesn't mean they're going to get awarded anything, but they may go to. As how I read it, I'm not a lawyer, so I will let some lawyers to verify that. Again, I'm not a lawyer, but it says to me, again, when people go, that doesn't mean they get awarded it. They can probably go before the Claims Commission because it's a state agency. So that's how I read it, and that's how we adjusted it in this, Representative Wardlaw.
I'm trying to understand why the importance of putting that in the bill. Can you walk me through where that came from?
Maybe people's concerns that the state agency is immune, and we'll make sure that people can get injunctive relief from the state. Again, I'm guessing because I'm not a lawyer, but that's how I read it.
Okay. Thank you, Mr. Chair.
All right, Representative Ray, you're recognized.
Thank you, Mr. Chairman. Representative Bentley, I guess my question sort of piggybacks on some of the things that Representative Mayberry was alluding to. A lot of the sections of this bill are just repealing various reporting requirements of some kind. Section 5, for example, was the one she referenced regarding teacher and administrator recruitment and retention. I would imagine that most school districts want to recruit teachers and retain teachers regardless of what race they are, right? They're looking for the best qualified teachers. A lot of these sections that are being repealed say, the district shall prepare a report. Does repealing the requirement, is there anything that would prevent them from continuing to develop a recruiting and retention report or a plan for all of their employees?
Oh, absolutely not. You and I have been in meetings together with our superintendents in small districts that are really struggling to recruit and retain, as always. I don't think I've attended a meeting with a superintendent that's not talked about that. And what they're doing is retaining folks. All right. So we've got some schools that went to a 4-day school district, a 4-day week, and that's really helped them with retention plans. So they're looking at years ahead on what the retention is going to be and how they're going to keep people there, because they know that retaining good teachers is vitally important for the education of their students. So I would say this precludes them not at all. It may remove some cumbersome reports so they can spend their time actually recruiting. I would say that.
Okay, thank you.
Representative Hawk, you're recognized.
Thank you, Mr. Chair. Representative Bentley, I'm going to take you to page 9, line 23. And it's regarding the University of Arkansas at Pine Bluff and the Division of Higher Education shall jointly promulgate rules necessary for the proper administration of the critical needs. It takes out the Minority Teacher Scholarship Program. And I guess my question is, I've heard from testimony today that we are not eliminating scholarships, but we are using it for critical needs. So you can tell me that the rules are still going to be promulgated. This scholarship is still going to be intact. There's still going to be a committee in place to be able to assign this scholarship. You're just changing the title of the scholarship.
Correct.
Okay, thank you.
And I think it's vitally important that we help those critical need areas. I think all of us want to vitally affect and take our money and use it wisely and effectively. I think our constituents expect us to make use of our tax dollars wisely and effectively, and I want us to do that. I have some very critical need areas in my district. I want to make sure that they're taken care of. Thank you.
Representative Bennett, you're recognized.
This is in regards to Section 5. Have we solved the problem of teacher recruitment and retention in only 3 years?
I'm not sure, not at all. This bill is not saying that. Again, as Representative Ray was saying, my superintendents are continually making sure they can retain good teachers and doing what they can to make it happen. That's why a number of them went to a 4-day week, so they can and they've seen a great retention with doing that. So I think superintendents are constantly looking to see how they can retain the best and the brightest teachers they've got there. That's why we did the increase in the LEARNS Act to give $50,000 to greatly help my small school districts that could not afford to pay that amount there. So it's helped them immensely. So by no means are we wanting to stop that.
Okay. I have another question.
You're recognized.
So in the Senate committee meeting, another senator mentioned about the need to have Black male teachers in certain areas of the state. So if this passes, how would that impact that population? Because that's a real issue.
I think that we should do everything we can. I would hope that people in the community would do what they can to support Black men that are going to education and help them with scholarships. I just don't think that everything, we're not going to fix everything with legislation, right? I want us to do everything that we can. And I think affecting things with critical needs will address that. I don't think it diminishes that one bit, actually.
Representative Collins, you're recognized.
Thank you, Mr. Chair. So I want to just ask a little bit more about why you put veterans back in this bill. So tell me why there's a difference. A preferential program supporting veterans, which I think is a good thing that should be done. I understand that. Why is it okay to not treat all people the same when it comes to veterans, but it is for different groups? What's the difference? We
have veterans that are Black, white, Hispanic, every minority you can think of, women, male, women, because veterans are a solid group and they cover every type of Arkansan out there. That's why. And they've also served their nation and put their life on the line and paid a big price. They actually, when they sign up, put their life on the line, and I think they deserve every respect that we can give to veterans.
Okay. Do you think that Black and women and other groups are not solid groups? Help me understand what that's.
I didn't say that. I said veterans comprise every type of minority and every ethnicity across the state. They're a solid group. Okay, just like I would say teachers. There's teachers of every ethnicity and every race, and so it's a solid group. It's not just picking out one sex. It's not preferring one race, sex. That's what the bill does. Stops preferential treatment based on sex or race.
I guess I don't understand why the overlapping aspect is different from any other group. There are Black Arkansans who are veterans and who are not veterans, who are women and who are not women. Right? So I don't really understand why that answer explains anything.
I'm sorry, that's my answer.
Okay. Another question I have for you is in section 2, this is unrelated. It talks about issuing permits by the Alcoholic Beverage Control Division. Mm-hmm. And it talks about how the existing language says that ABC shall consider lack of diversity in ownership and financial interest in the geographic area at issue. Do you realize that this is diversity in ownership is not talking about racial diversity? This is about not allowing families to control permits in a certain area.
I did reach out to Joy. I'm sorry to interrupt you, but I did reach out to Joy Leonard on that and to make sure this is not in any way change anything we're doing with the number of liquor licenses out there. So you can visit. We're happy for you to reach out to Joy Leonard if you want to on that.
Well, no, it really wasn't about the number of liquor licenses out there, but I was wondering if you realize that the lack of diversity in ownership is referring to control by families and individuals that are related in a certain geographic area.
I'll have to get with her and get back with you on that.
Okay. Thank you.
Representative Clowney, you're recognized.
Thank you, Mr. Chair. Representative Bentley, I want to circle back. I appreciated Representative Ray's point about burdensome and Representative Mayberry's point about burdensome reporting requirements. I guess my concern is more with the language on page 11, which isn't about reporting. It's just about the prohibition of discrimination or preferential treatment by state entities. I agree with Representative Ray that a school is certainly welcome to come up with their own retention and recruitment plan. However, the way that I'm reading the language on page 11, any of those plans cannot include what we're calling preferential treatment based on whatever race or national origin. So again, to return to my example, I think that there are certain jobs where, in public school districts in particular, but all over the state, where say national origin is part and parcel of the ability to do the job. In other words, if you are looking for a Marshallese liaison, you would theoretically want that employee to be Marshallese. We would want to recruit a strong pool of candidates. But under this bill, the way that I'm reading page 11, a district could not, in fact, come up with a recruitment and retention plan that even considered national origin, that we would prefer somebody of one national origin over another to fulfill this job, when in fact I think it is part and parcel of the job. I guess my question for you is, do you read that language on page 11 the same way?
I would just say I would agree to disagree with you that I want the best and the brightest person in that position, regardless of where they're born. I want it based on their merit and what they can do. And if they're going to be a translator, they're going to have to be able to speak Marshallese. So to me, it's going to limit who you're going to be able to hire. So I want the best and the brightest, dependent. I don't care where they're born and what color their skin is. We need the best people in that position. So it's not going to preclude them. If you're going to require somebody that can translate Marshallese, you're going to definitely limit who you can have in that position if you want to continue going back to that situation. So,
well, with all due respect, these positions require a lot more than just knowledge of language, right? There are deep cultural differences between a lot of members of these communities. For instance, I'm thinking back to during the COVID pandemic, where Marshallese liaisons between whether it was schools and the community, or the Department of Health and the community, played a really critical role in gaining trust, right? It's a lot more than knowing a language. So I just want to reiterate that I think there are some jobs where we have to acknowledge college. Things like national origin are part and parcel of the job, and we should be able to give preferential treatment to folks who are going to necessarily be better at the job if they have those national origins. It's critical for building trust within our communities. But I have one more question, which is, which I have forgotten now as soon as I open my mouth. No, I wanted to go back to your point. You mentioned that you think that, government shouldn't fix everything, and certainly I agree with you on that. I think when we talk about government, especially at this table, we have an idea of like, this is the government, right? A big, long, scary table with rooms full of people making decisions. But your bill's talking about public schools. So I guess, is it your position that public schools have no role to play in encouraging, for instance, girl-specific programming?
I never said that. No, I think that they could have a club that's of girls. I think we should have clubs that are specifically girls, and we could have people in the community help to donate to fund that club, is what I'm saying. So that's what I was saying. I think it's great for the school to do things. I want girls sports. I've been an avid person to make sure we have girls bathrooms. I want things specifically for girls, but also it's not our job to you were talking about funding. So I think our funding could come from the community. I mean, I'm a member of our a lot of civic clubs where I help to donate and do great things in our community, apart from being a state legislator. So I think there's parts for the community. Again, even with Marshallese, there's parts for the community to step up and do their part and make sure that things that are being taken care. I know you are. I am out there listening to my community all the time and making sure their needs are met, regardless of their skin color or what origin they are.
Can you tell me in the bill where it's limited to discussions of funding? Because I'm not seeing that. I'm saying that no school should get preferential treatment. So what I'm wondering about is things like offering a classroom for this club to meet in. I mean, that is giving preferential treatment to a group based on gender. It is. I mean, I know that that's not your intent.
If we're offering the classroom to every club, then we're not doing preferential treatment. If we're saying every club, regardless of whether you're a boy club or a girl club or whatever you are, you can use the classroom. That's not giving preferential treatment. I think you're distorting things a little bit so on that, and that's just my opinion.
Okay. If a school has a club and they have a Girls on the Run club or they have a Girls in STEM club, that club is, by virtue of being for girls, giving preferential treatment to girls.
As long as the school offers them to have a Boys on the Run or a Boys STEM club, they're not offering preferential treatment. We're allowing different clubs for different interests. We're not giving preferential treatment.
Okay. Again, we'll have to agree to disagree on that.
Representative Bennett, you're recognized.
Thank you. Representative Bentley, do you agree that black and whites, do you agree that we have different experiences, life experiences?
No doubt.
Okay, so kind of piggyback to what Representative Clowney was saying. In some instances, like having a black male teacher in classrooms help certain populations. And with this bill, you're not going to give any mention to that, or it's going to be against the law. Certain people have certain abilities to do things in communities that don't look like the majority. And so students learn better when they have somebody that look like them. And that's something that maybe you can't relate to, but that's something that as a race, as black people, we can relate to certain things. In this bill, you take away that voice, and we should be trying to make bills. We should be trying to build up our education, our population, so we can be a more diverse state. And with this bill, we're stepping backwards. It's certain things that you as a white woman, you're not going to understand. It's certain things that we understand and we can relate to black people better than what a white person can do. So in this bill, it takes that away.
I would completely disagree with you.
But
this bill
again,
stops.
You're disagreeing, but you don't have the same life experiences like we do.
I really take offense to that. I really do take offense to that. And my children were growing up in school. We had two young black boys in that class, and those two boys were in my home. They were treated. I never was racist in my home, and my parents were never racist. We didn't allow racism in our home. And those two young boys, Josh and Royce, called me mom, and they still call me mom, and they still bring their kids to my house. I refuse to have racism in my house, and racism is going to be stopped when we, one family at a time, stop racism in our home. This has nothing to do with racism. Racism is something hateful and evil, and I despise it, and this bill just does nothing to discriminate that, does nothing to encourage us to make sure we have mentor young black men to be good teachers. We want good young black men to be teachers, and I really am offended by you trying to say we're going forward with this bill and getting rid of discrimination and outlaws discrimination. So that's where I stand on it.
All right, thank you.
All right. Seeing no further committee questions, no. Representative Long, you're recognized.
Thank you, Mr. Chairman. Representative Bentley, if I'm reading the bill correctly, this affects higher education in Arkansas too, as far as public schools, correct?
Yes, sir.
And I was just reading over the an article about, I guess it was in June of 23, when the U.S. Supreme Court ruled against Harvard College and University of North Carolina because they had affirmative action policies in place. So they said that the court found that such policies violated the Equal Protection Clause of the Constitution, as well as Title VI of the Civil Rights Act of 1964. Do you think if we don't pass this law, it will open up the state of Arkansas to being sued, because this appears to be settled by the Supreme Court, and we have an opportunity?
I think it very well could. I think it very well could, Representative Long, without a doubt. That's exactly what we're trying to do, line up with federal law. Things are not what they were 60 years ago. And again, we read exactly about the Supreme Court case and the president's executive order on ending affirmative action. Thank you.
Thank you.
All right, seeing no further committee questions, we have a long list of people signed up to speak for and against the bill. Thank you, Representative Bentley, for your presentation. This time I would recognize Preston Clegg to speak against the bill. Preston Clegg. Once you take your seat at the end of the table, if you would, state your name for the record and any group that you're here representing, and then you'll be recognized to present your testimony.
Good morning. My name is Preston Clegg, and I'm the pastor of Second Baptist Church in downtown Little Rock, a congregation that cares about justice and equity and inclusion, and I appreciate your time today. We have learned as a church that we do not see all the truth through our two small eyes, which is why we need a diversity of views and experiences and thoughts. This is the value that we see in DEI programs. We do not believe that DEI programs are antithetical to merit. We believe they seek to heal historical and persistent wounds so that merit has a chance. Historical, political, and legal wounds demand historical, political, and legal redress. Before, not after, we can speak of merit and equality. There is a temptation to want to move on from all this talk of injustice and harm and inequity, I know. But it's possible to move on without really moving forward. Moving on is a way of forgetting, but moving forward demands we remember. Moving on wants to overlook historical harms whose insidious impacts persist even in this present moment. Moving forward demands we look at the harm so as to heal it. DEI work helps us move forward, not just move on. There is a temptation to say that DEI programs are just another form of oppression, pitting one group against another. But that's a misreading of our own history. DEI work seeks the same intentionality and specificity in our acts of healing that we committed in our acts of harm. For most of my life, my privilege looked for all the world to me like merit. I have worked hard, but under all my hard work was a current of privilege I could not see, and an inheritance of benefits I neither earned nor deserved. Those same currents swirled differently for different people. And so long as we refuse to be honest about these historical currents, privilege will continue to look like merit, and equity will be unfair. There may be a day when DEI work is no longer necessary. I pray for that day. But it's probably not the day when not a single black legislator that I'm aware of supports this bill, or when we're last in maternal mortality rates, or when women make 78 cents for the dollar that every man does. This is not the day when DEI work does not matter. I want you to know that I pray for you, as does our congregation. And I'm asking you to do the right and hard thing today, and include in your deliberations the voices which have for too long been dismissed or ostracized. I ask you to vote no on SB 3.
Thank you. Do you want to take questions?
I can.
Are there any questions? All right, seeing none, thank you for your testimony. Next, we have Robert Steinbuck to talk for the bill. Please recognize yourself, and then you're okay to go.
Thank you, sir. Is this on? Can you hear me? Yeah. My name is Robert Steinbuck. I'm a law professor. I'm a columnist. I'm here in my individual capacity, of course. Oh, bear with me. I need to change the glasses. Representative Bentley did such a wonderful job presenting the bill. I thought what I would do is just fill in some of the gaps that she had mentioned might require a little bit analysis from a lawyer, and I am that. I apologize in advance. I'm going to try to address the questions that were raised by various representatives without recalling the specific names of most of you. One question was, can we point to any statistical harm caused by preferential treatment? The answer is yes. You can look at two of my articles, one of which was cited by the U.S. Supreme Court by Justice Clarence Thomas for precisely that point. That article and another article highlight that when I examined for a group of law students, we examined them based on race, and we were able to realize that the bar failure rate for the African American students, for first-time bar takers, was double that of whites. Let that sink in. The bar failure rate for blacks was double that as for whites. Now, clearly, it's not a function of their race. It's a function of race-based admissions that allowed students into a school that was above their level. And had they gone to a properly matched school, they would have done very well on the bar exam. This is just one statistical example of why preference systems actually often hurt those they're designed to help. I do remember that Representative Clowney mentioned a point, I know because I've spoken with her offline, and she mentions the point that we want a couple of phrases. We want to mirror our populations in, say, our teachers. We want liaisons in schools to be of the same race same race as the population that they're caring for. And the example, of course, that she used was the Marshallese. And then, indeed, when Representative Bentley focused aptly on one aspect, that is language, he said, well, of course, you're going to have to speak the right language. Representative Clowney said, well, it's more than just language, a point I'm sure that Representative Bentley agrees with. But think about this for a moment. Representative Clowney's comments reflect her sound judgment that there are certain skills that are necessary to represent the Marshallese community. If she were to apply for that job, she would be a capable candidate at minimum. Imagine a Marshallese.
Point of order.
Recognized for point of order.
Is it appropriate for the witness to be discussing committee members in this way? And
I mean, at this point, I think he's trying to make an analogy or make a point. I've not heard anything that I would consider to be offensive or abusive, but just be aware that we typically try to avoid referring to committee members specifically, and certainly if it in any way could be deemed to be offensive or in any way, avoid that.
Of course, Mr. Chairman, thank you. My intentions were to compliment Representative Clanny on her would-be abilities to represent Marshallese. My point was that if she were to apply for a job, she would be very capable for that job. You could imagine that a Marshallese individual without any other skills and knowledge of his own community that could apply for that same job, and under a preference-based system that would only permit the application of Marshallese, that latter candidate would beat the very qualified representative. That goes back to Representative Bentley's point. We need the most qualified people. Those most qualified people may indeed frequently be of that community. But to judge them first based on their race or national origin is a mistake. There is a former colleague of mine at the law school who had done a fellowship at UCLA, and he had done a fellowship on legal issues affecting the gay community. He was the first holder of that very prestigious fellowship. And interestingly enough, he was not gay. He is not gay, because they chose him based on his merit, based on his skill, based on his abilities. There was a question raised about gender programs in schools, amongst other areas. We need to focus on the language, as Representative Ray has often pointed out in every bill. We need to focus on the actual language of the bill. The bill says that state government, including localities, shall not grant preferential treatment on the basis of race and sex, etc., in the following categories and the following categories only: hiring, contracting, and admissions. That's page 13, lines 18 through 19. That's where the preferences are prohibited. It speaks nothing about the issue of girls' clubs and opportunity programs. Another representative raised the point about a bill that is being that is being modified in this bill, or would be modified when this bill passes, that was originally passed in 2021. And the question was, what major changes have taken place? And in fact, the representative pointed out that there was a Supreme Court decision. It's important to focus on this Supreme Court decision just a bit. The U.S. Supreme Court said that preferences are unconstitutional in higher education admissions. The logic of that opinion applies far more broadly, right? That only dealt with admissions because case law only deals with the case that is before the court. But the notion applies equally to hiring and contracting. And so if you think about it, all SB 3 does is catch up to what that Supreme Court opinion ultimately portends. But instead of being on the back end of history, we will be on the front of history. 10 states have passed this law already. We won't be the first. None of those states have fallen off the continent. They're doing just fine, but we will be at the vanguard. A point about the issue why in this bill is there a commentary about veterans. Because the last time this bill was introduced as SB 71 2 years ago, there was no mention of veterans. Now, to be clear, the old bill did not take away preferences for veterans either, because I just read you the section that dealt with the removal of preferences, and you heard no language from me, as no language existed, that removed any statutory preferences for veterans. Nonetheless, the objection had been raised 2 years ago, and as a consequence, this bill put into place language that made clear what was already in the last bill through implication, that veteran preferences are unaffected. Now, it strikes me that nobody objects to veteran preferences. The bill objects to other types of preferences, and the question was asked, why one preference yes and other preferences no? And it's a fair question. Ultimately, a question for you all to decide, as is all of this. But as Representative Bentley pointed out, we have veterans, specific individuals who have done specific things in their lives. And as a consequence of those actions, this body has decided that they're entitled to certain preferences. You want to change your mind on that? Fine. I'm not suggesting you should, to be clear. But that's the basis for veteran preferences. The basis for race and sex preferences are merely what you're born with. And that is incongruent with what the Constitution requires, as stated by the Supreme Court, and the direction that this country is going towards in having a colorblind society. There was a question about the ABC permits, the alcohol beverage control permits. And the claim was made that the diversity reference in that language did not refer to racial and sexual diversity. I'm not sure that's right, but in any event, the subsequent language that was put in place in this bill deals specifically with competitiveness. So if there is a concern regarding ABC permits in terms of ensuring that one family doesn't own too many liquor shops, the replacement language better addresses it in any event. Let's see. Oh, that's it. Those are all. I apologize. That was my last point, based on the comments and questions that were raised. And should anyone have a question, of course, I'm happy to answer.
Thank you, Mr. Steinbuck. Representative Clowney, you're recognized.
Thank you, Mr. Chair. Professor Steinbuck, can you please point me again to the language? I just missed it. Yeah. Where you said that this would not apply to any sort of clubs.
Right. So it's page 13, lines 18 through 19.
I think you may be looking at, or maybe I am, looking at an old version.
I'm sorry. You're right. I pulled the SB3 off of the Senate site, and Representative Bentley has made some minor changes, actually, that were raised by Representative Wardlaw, and I wanted to address those. So bear with me. Here we go. Page 11, lines 24 through 27. The state shall not discriminate against or grant preferential treatment to an individual or group on the basis of race, sex, and the other factors in matters of state employment, public education, or state procurement.
Okay, and I think my questions really had to do with public education, which is why I considered them falling under that section. I was just curious. Thank you.
I see. Thank you, ma'am. I understand your point. I see.
All right. Any other questions by the committee? Representative Bennett, you're recognized.
Mr. Steinbach, is that?
Yes, ma'am.
Do you agree that black and whites have different experiences, life experiences?
Absolutely.
Okay, so I guess my next question is, when you said that the other states have passed this and they're fine, how do you measure what fine is, and what's the matrix there in knowing that it's fine?
Well, I'm not sure. Does the first part of your question bear on the second part? Meaning, fine relative to...
I guess what I'm asking too, what makes you an authority on these things?
Okay, that's a different question. I'm happy to answer that. I'm well published in these issues in legal journals. I was cited by the U.S. Supreme Court. So I don't know. I think that's okay in terms of authority.
Okay, and so I guess my question would be, do you agree that black and whites have different experiences in life?
The short answer is yes, but if I may just expand slightly, and that is, I think we can refer to populations in general and say that populations have different experiences overall as a collective, and that's why in sociology we refer to different groups. But I think when it comes to hiring, contracting, education, we always look at the individual, and that's what we need to look at. So yes, I think on average, as Representative Clowney aptly pointed out, you're more likely, if you're hiring a liaison for the Marshallese community, to wind up hiring someone from the Marshallese community because of those differences in experiences. But predetermining that is what this law would prohibit.
Okay, and I have another question. So when you said that the other states that have passed this are doing fine, how do we measure what fine is? What matrix or what are we basing this on?
Well, my focus, albeit not exclusively, has been in the education context, and we've seen that when we remove preferences in higher education, we don't wind up with a significant change in the number of minorities attending higher education. What we see is a redistribution, and that redistribution produces a better outcome, not a worse outcome, because students are better matched to the school they attend instead of attending a school that they were given a very large preference on, and they were put into a situation in which they cannot often flourish.
And that's documented where I mean,
you could see my article written with Richard Sander from UCLA, cited in the Supreme Court decision, talking about those issues. I'm trying to remember precisely the title, and I can't. It's published in the Journal of Legal Education 2 years ago or so, a year ago, something like that. I can happily get you a copy if you like.
Thank you.
Yes, ma'am.
Mr. Steinbuck, I have a question. You mentioned the 10 other states. Can you give us a list of what those states are?
Not at the moment. I can tell you that one of them, I wish I had it with me, one of them is California, that enacted this law through plebiscite, meaning not through the legislature, but through the people, over 20 years ago. And there was an attempt actually to repeal it more recently, which failed. And as we well know, of course, California is a very left-leaning state. And yet the people of California enacted this, and it remains the law, notwithstanding an attempt by the legislature, which is more liberal than is the populace, to claw it back. But I'm afraid I don't have that list in front of me, and I would do no justice to it by trying to guess.
All right. One of the points that's been brought up is basically the historical perspective on how different groups have been affected over the course of American history. I think it goes without saying what some of those examples are. How do you square that, given the history of how certain groups in this country have been treated? As recently as the 1960s, we didn't pass the Civil Rights Act of 1964. Wasn't really, in the grand scheme of things, that long ago. So how do you square what you're trying to do with today, given the history of our country? I'd like to hear your response. Thank you.
Yes, Mr. Chairman, thank you for the question. So, of course, there hasn't been hundreds of years of discrimination. There have been thousands of years of discrimination. And the evolution of humankind goes in large leaps and small leaps, and it's much like technology. The years of the lack of technology are huge, and the time in which thank you, and the time in which technology has improved our lives is relatively short. So that's all to say that in the 60s, we had truly a diverse, separate, as Representative Bentley pointed out, populations, black and white. And we did two things. One, we passed the Civil Rights Act, and Arkansas has a state version, of course, of that as well, which prohibits discriminatory behavior. In addition, President Johnson put into place the executive order, which somewhat mirrored one created by President Kennedy a few years prior, that used that language that Representative Bentley aptly quoted about affirmatively acting. And the notion was that at the time, our populations were so disparate that we needed to, as the phrase went, put a thumb on the scale so that we could have people who are entering schools or employment or contracting some slight benefit to offset what would be a very hard way to compare candidates. Over 60 years, that notion became what is today affirmative action. And I say that meaning it was never designed to be affirmative. And I've seen it in my studies of higher education admissions. An overwhelming benefit given solely based on race, not to certain individuals who, as a function of their race, may have suffered some detriment, but solely based on race. And in fact, as Justice Thomas references in his opinion in that Supreme Court case that I referenced, he says, often these benefits are going to very wealthy minorities because it's solely race that is a factor. And so, yes, we've had hundreds, thousands of years of discrimination. In the 60s, we moved into a different environment in which we prohibited discrimination. We separately set up this preference system that was designed to be limited, minor, and short-term. It became large, long-term, and dramatic. And it's only that last part of what has transpired over the last 60 years that we are saying it's time to end. It's time to end because 60 years is an eternity in the advancement of humankind. If you look back to where we were 60 years ago, it's like looking back to the caveman times if you were comparing technology. We have made advances that are profound in our society, and as Representative Bentley points out, it's time to look forward, not backwards. And may I just add, Representative Bentley pulled that list about the states, California, Washington State, Florida, Michigan, Nebraska, Arizona, New Hampshire, Oklahoma, and Idaho.
All right, thank you very much. Any other questions of the committee of Mr. Steinbuch?
Thank you.
All right, seeing none, thank you, Mr. Steinbuch, for being here. We appreciate your testimony. Next, I have signed up to speak against the bill, Janie Ginocchio. I hope I said that correctly.
Close enough. Mr. Chair, if I could ask for your indulgence, I'd like to switch slots with Mr. John Kelly. He's a liquor store owner who is very confused about Section 2, and he also has to go hear a bill in House Rules at 1, so I want to make sure he has the opportunity to speak.
I don't have any objection to that, Mr. Kelly. If you would state your name for the record, identify any group you're here representing, and you'll be recognized to speak against the bill.
Thank you. My name is John Kelly. I am on the board of UBRA, an association of retail beverage owners. I'm from Little Rock. I want to be real brief. It's Section 2, and of the 470 odd lines, it's only 6 lines. I would just say that, you know, the critical thing to me is really it's 2 things. One has to do with the fact that there's an elimination and then there's an interpretation. And I believe both the 3 items, including the 2 that are eliminated, they're all statutory. And as I understand it, and I could be wrong, but statutorily that means that there's it's a law. And as I understand the way law moves, what is actually done is going to be based on case law. So I just want the committee to understand that there's a lot to the possibilities depending on how that is interpreted. And I just want the committee to be aware that there's opportunity for the whole dynamic of how applications are issued and what is being considered that could be affected by this. The other thing that I would say is that, I'm not quite sure. I found out about this bill last night, and I'm sure there's some logical reason why it ended up in state agencies, but it was certainly to me a bit of a surprise to have had something that dealt with alcohol to not go through the Rules Committee or not go through CC, City, County, Local. And I really think that is it. I certainly don't want to take up any more time with this very important discussion, but as a liquor store owner, I believe that in reading this and my interpretation of all this is that it could have a dramatic impact on our business. And I will kind of close with saying there's a whole bunch of other bills that are coming along. 97 and 98 are mixed in, and this what's being done here, in my opinion, could have dramatic impact on the industry that I am in and the industry that I represent.
All right, thank you, Mr. Kelly. Any questions of Mr. Kelly by the committee? Seeing none, thank you, Mr. Kelly, for your testimony. Next, we have signed up to speak against the bill. I'll go back to Ms. Janie Ginocchio. If I've mispronounced that, please correct me. If you would, identify yourself for the record, state any organization you're here representing, and you're recognized to present your testimony.
Thank you. Good morning. My name is Janie Ginocchio, and I'm the co-founder of the Arkansas Nonprofit Initiative and ArcLegBillTracker.com. And I'm also here to talk about Section 2. We've been trying to raise the alarm about Section 2 since it was Section 1 of SB 71. So I want to be very clear today. Section 2 is a direct attack on small businesses, local communities, and the very principles of transparency and fairness that this body is supposed to uphold. Section 2 of SB 3 shifts the focus of liquor permit approvals from ensuring a balanced market that protects small businesses to prioritizing consumer benefits like lower prices and convenience. What does that mean? It means large corporations, big box stores and chains will dominate the market while small independent liquor stores are pushed out. And it means that residents will lose their voice in shaping their own neighborhoods as public input and community concerns are sidelined in the favor of corporate profits. Because I want to make it very clear to you that the benefit of competition for consumers that's referenced in this change is the benefit of competition for consumers of alcohol. Not just consumers generally, only consumers of alcohol. So you are creating a preferential class in this bill with Section 2. But what's even more outrageous about all of this is that this provision is buried in a bill that has nothing to do with liquor. I spoke to, so this is amending Act 2323 of 2005. I spoke to former Representative Tim C. Hutchinson, the sponsor of that bill, and he very clearly told me that the intent of that, when he put diversity of ownership in there, was whether it was a monopoly or not. It had nothing to do with the identity, the race, or gender of the owners of the company. That is not the type of diversity that this is referring to. This section is not germane to this bill at all. So this bill was buried in a bill that has nothing to do with liquor. It's not in the title. It's not in the legislative intent. It's not being discussed in the appropriate committee. And it wasn't shared with the people who would be most impacted. As you heard, the liquor store owners didn't find out about it until last night. And this is the second run at this. They've tried this for 2 sessions, and this is the first time they're hearing about it. Sorry. I'm just very angry at the lack of transparency and what's being done to the people of the state of Arkansas here. This isn't about good policy. This is about sneaking something in without scrutiny, without accountability, and without debate. So the committee has a choice today. You can vote for backroom deals, corporate favoritism, and the erosion of local control. Or you can stand up for small businesses, for transparency, and for the communities that you were elected to represent. I urge you to vote no on SB 3. Reject this blatant power grab from the Senate. Send a message that this kind of secrecy and disregard for the people of Arkansas will not be tolerated. Thank you.
Ma'am, before you leave, we do have a question from the committee.
Yes.
Representative Rose, you're recognized.
Yes.
Yes, thank you, Mr. Chair. I was following, I feel like most of what you were saying. I guess I kind of took issue with the accusation of lack of transparency in a bill that was publicly filed, has gone through the Senate, is in the House. It's not hidden. I just was curious if you could speak to why you believe that there's a lack of transparency.
Well, as I said in my testimony, alcohol is never referred to in the title or the legislative intent. Senator Sullivan has said repeatedly that this bill is about education, employment, and procurement. Liquor permitting has nothing to do with any of those. He has refused to discuss Section 1 when it was Section 2. When it was Section 1 of SB 71, it went through the entire process. It was never discussed or explained to any of the bodies. It was never discussed in Senate committee. It was never discussed in the well. And we specifically texted Senator Sullivan.
I'm just talking about.
I'm just telling you
I'm asking about SB 3.
Yes, I'm telling you about SB 3.
Okay.
It is not in the bill title. It's not in the legislative intent.
Whoa. Let's not argue.
Okay, well, I'm sorry,
No.
Okay, I apologize.
Just everybody calm down.
We texted Senator Sullivan directly and asked him to explain the bill, and he said that he was going to leave that to committee debate.
Listen. Let's just not talk over one another. Let's be respectful. If she's answering a question, let's let her answer. And if he's asking a question, let's let him ask his question.
Okay.
And let's try to do this orderly. So I'm not sure where it left off. Had you completed your answer?
No, I hadn't.
Okay, go ahead.
And as I said, he did not discuss it during the Senate committee. He did not explain it during his explanation in the Senate committee. It was not explained in the well in the Senate. We texted him directly and said, Senator Sullivan, can you tell us about Section 2? He said, I'm going to leave that before the Senate committee meeting. He said, I'm going to leave that to committee debate. And then he specifically did not talk about the bill. There was never any discussion of it. Again, and this section is not being routed through proper committees. If this were so, y'all have a supermajority. Why isn't this a standalone bill? Why is this buried in a bill about affirmative action? It's not about affirmative action. Why can't it be with SB 7097 where it's germane? That's about liquor permitting as well. Why is this in a bill about affirmative action? It has nothing to do with affirmative action.
All right, Representative Rose, did you have another question?
I do.
Go ahead.
Is the information in Section 2 publicly available in this bill that went through a Senate and House committee? Yes or no?
Yes.
Okay. Thank you. That's all, Mr. Chair.
SB3 still or not.
All right, ma'am, do you have any other remarks?
I had to take
another. Yes, even though it's publicly available, the sponsor has a responsibility to explain all sections of his bill, and he has refused to do so multiple times.
Looks like we do have one more question. Representative Ray, you're recognized.
Thank you, Mr. Chairman. Did you testify to this section of the bill on the Senate side?
No, because we were waiting for Senator Sullivan to do the right thing and explain the bill and have a committee debate about it, and he didn't. So we're bringing it up now because we feel like y'all weren't made aware of it and that something is being passed through, flown under the radar for you legislators in the House and for the people of the state of Arkansas.
Yeah,
okay. My follow-up question, and I apologize if I'm putting you in a difficult spot. I had to step out for a second and I missed what the previous person had said. I understand he was a liquor store owner.
Yes.
Can you summarize what he said? Because I think it was on the same point.
Yeah, he basically found out about this section last night when I told him about it.
That's all he said.
Well, and that he had grave concerns about what this would do to to the industry.
What were his concerns?
I mean, why am I being asked to summarize somebody else's testimony? I'm sorry.
If you don't want to, that's fine.
Well,
I said I apologize if I'm putting you in a difficult spot to summarize something someone else. If you don't want to, it's totally fine.
I mean, he reflects industry concerns that this bill was not put in the proper committee, and that this is the first he's heard of it, and that he has concerns about what impact. He's afraid that it negatively impacts, but he doesn't know because nobody's told him about it.
It's just like some small attempt at nitpicking based on what I've seen.
Additional remarks?
Again, transparency. This is not germane. You shouldn't vote for this bill.
All right. Thank you very much. Next, we have Haley Schaffner to speak against the bill. Ms. Schaffner, if you would, identify yourself for the record and any organization you're here representing. You'll be recognized to present your testimony.
Hi, good morning. My name is Hallie Schaffner. I'm a farmer in Jackson County, just outside of Newport, where I farm soybeans, corn, rice, and wheat. I'm here representing myself. I'm here to express my deep concern in opposition to SB 3 because I am part of a group that does receive and will continue to receive preferential treatment from the government, including in the code of the Arkansas Department of Agriculture. And I understand that that code is not referenced in this bill, but I believe that my experiences are relevant to this discussion. You see, I am a young beginning farmer. There aren't that many of us in agriculture. The average age of a farmer is 58, and that's because young farmers face significant barriers in starting their own operations. They lack the resources or established credit and assets to get operational loans, and the government recognizes these barriers and writes specific language and programs to help them overcome these barriers. They recognize the importance of young farmers as the future of agriculture. So the programs that they've written are low interest loans, grants, training programs, and I cannot help but wonder if you stripped the code of this language, this specific language, and these programs, if young farmers would not be overlooked because of their lack of resources. I say this to illustrate the importance of specific language and programs that help Arkansans who, like young farmers, at no fault of their own, are, because of their situation or birth, forced to begin 15 feet behind the starting line. Groups like people of color, women, young people, young farmers,
So
seniors,
they're trying to
people
do
with
a stretch
disabilities,
here, or the people
and
that are
yes,
against this bill are
veterans.
somehow saying that this should
Under
be
the
in
guise of
another
equality,
committee.
SB 3 will make it harder for these groups to succeed in careers
Let
as
me
teachers.
go ahead and stop this and go to Judiciary, see if what they're doing.
$2,000 back.
Assuming that's what they were paying.
This is the insurance bill, the bad insurance bill.
For them to put into their account and use as they see. I don't mean that in a pejorative way. It's not meant to be part of what the plaintiff recovers for his or herself. It's meant to help cover what they paid for their health care service.
All right, I'll move on. It's a dead horse at this point. The made-whole doctrine allows it to go back under the law as it exists now, and I'll move on. And here's the good news. Too, Senator Rice and Senator Clark already addressed a series of questions I had on the direct relationship between past medical costs and pain and suffering and other non-economic damages, so I'm going to skip those entirely. If this law passes, then if you're injured through no fault of your own, you can recover less if you have health insurance than if you don't have health insurance.
Well, that assumes that people without health insurance are paying the full amount, or if anything. Here's another quote from a law article in South Carolina. Nationally, less than 5% of patients actually pay this full, I'm sorry, where's my uninsured? While all uninsured patients are expected to pay the hospital's full charges, it appears that in fact less than 5% actually pay the full charge. I've got a piece from the American Hospital Association from 2021 where the American Hospital Association says the uninsured don't pay anything on their bills the vast majority of the time.
A lot of them
So
are illegal.
that first assumes that the uninsured are having to pay the full amount of bill. I don't think that that's what happens. Secondly, what I would say is, hey, Mr. Uninsured, what did you pay? Nothing. Then you don't get anything for hospital bills because you didn't pay anything.
Right.
I paid half of it. Well, then you get half of it because you paid half of it.
All right. So let's follow up on that. So I've got that American Hospital Association report right in front of me here. And it says that in another section.
Here's a link to the other bill.
Patients ineligible for financial assistance and patients whose care is paid for by other types of insurance, e.g. workers' comp, auto liability insurance, et cetera, are the only patients that may be billed full charges. So I just want to note that that report also says that. But to your other point, when you say uninsured folks pay 5% or less nationally, that's up to the healthcare provider in each instance.
That's right. That's correct.
And so they might charge 5%. They might charge 50. We don't know.
That's right.
In each instance, that's up to them. So a person who is uninsured certainly has the potential of paying more out of pocket than a person who is insured, if this becomes law.
Well, I mean, if they're going to pay any hospital bills, it's going to be out of pocket. That's the case today.
Yeah.
But they'll be entitled to recover whatever they pay from the defendant.
So they can recover more. They can recover more than someone who pays a copay.
They will recover what was paid.
And it could be, if the hospital doesn't give them a discount, it will be more.
Sure. Yeah. Let's base it in reality, and that will differ from case to case.
Okay.
But if you're uninsured for various reasons, I mean, you're making an assumption that you're uninsured for, I'm not sure what reason. Sometimes that's a choice that people make.
Right. And I think if this bill passes, more people will make that choice because there's a disincentive
I would
to get health
disagree with
insurance.
you. No, I would completely disagree with you. But I mean, you're also discounting the fact that you have charitable hospitals because of what they do. They treat people, and you know that the federal and TALA laws do not allow a hospital to reject treatment of a patient. You know that, whether they have insurance or not. They cannot turn somebody away from an emergency room. They have to treat them. So it's not whether they can pay or not. They have to provide care and treatment. That's the right thing to do. But we should acknowledge that. We should understand that. And that should be a calculation in any of these policies that we're presenting today. And I would argue it's a huge consideration.
The amount you can recover if this bill passes will vary depending on whether you have insurance or the type of insurance you have.
Sure. And I don't know why we want to take two different plaintiffs who paid two different amounts for their past medical bills and have them recover the same. That's the whole point of this bill.
Is an insurance premium an out-of-pocket expense?
Sure.
In real life, it is.
Yeah, but it's not as a result of a tort that you're paying it. You're paying it because you need to, and it's the responsible thing to do if you can afford it.
But it does reduce the tortfeasor's liability.
No, I disagree with that. This bill sets things in reality when it comes to that silo of damages we've been discussing. Let's use what's real, not some inflated number that's not paid.
But your health insurance premium is not an inflated number that's not paid.
I'm sorry?
The health insurance premium is not an inflated number. That's a real number that I pay out of pocket.
No, but the tortfeasor did not cause you to have to buy insurance and pay the premiums. That is not a cause.
But it does affect their liability.
Whose liability?
The tortfeasor.
The fact that they have insurance, the plaintiff has insurance?
Yes.
It very well may impact what they recover for past medicals.
Yeah.
Yeah. But
okay. We talked more about really, healthcare coverage today than I anticipated. And I'm just curious if you considered limiting this bill to that area.
To which area?
Medical malpractice cases.
No. Why would we treat it differently than any other case? Why should plaintiffs in a medical malpractice case recover something different than somebody in another negligence case? Again, what was paid and what was accepted? We think that's fair.
Okay, I just want to mention for my colleagues here that 9% of all lawsuits in Arkansas are tort cases. 5% of the 9% are medical malpractice cases. So it's a very small percentage of cases. Less than 5% of cases go to court, and the average jury award in Arkansas is under $5,000. Do you have any reason to dispute any of that?
I have no idea the source of that.
Okay. I wish that I had anticipated.
Those numbers again, Senator Tucker.
Yes, sir. 9% of lawsuits in Arkansas are tort cases. 5% of tort cases are medical malpractice cases. So 5% of 9%. Also, less than 5% of cases go to trial. So again, that's less than 5% of the 9%. And the average jury award in Arkansas is less than $5,000. So I want to talk about, please.
I would just like to know the statistics of those that settle out of court and what the cost of that is. And it's a dramatic cost. I can tell you, I mean, you know, I know of individuals who have been sued because the doctor wouldn't prescribe opioids to the patient. So guess what? The insurance company had to pay for the attorney to come and spend all day long to represent that physician who did exactly what they were supposed to have done, still incurred a huge amount that was never recovered. The lost wages of that physician was never awarded damages for being away from their practice all day long, and patients that they didn't see had to cancel clinic. I mean, there are so many instances where there's all these tertiary expenses.
I agree.
But it's for everybody. It's for everyone. And so again, this goes back to what a receipt shows of what was actually paid.
Right.
And it's really that simple.
Okay. You just made me think of another example. Have we ever heard of a case in American history where a health insurance carrier denies coverage for a service? Does that happen?
Sure.
Yeah. And so sometimes an insured has to sue their first-party insurance carrier to get coverage for an expense, correct?
Yes.
And if they have to pay a lawyer to do that, then they won't be able to recover the attorney's fees on that side either.
For suing the insurance company?
Right.
I think they may have some penalties and maybe a fees if it's a bad faith case, yeah.
But only in a bad faith case.
Yeah.
Okay. So I pulled the insurance numbers for Arkansas for private passenger auto and commercial auto for the last 5 years. So this is what we're talking about in terms of insurance companies in Arkansas. This is from the Arkansas Insurance Department. So in private passenger auto, I got 5 years here. Bear with me on the numbers. 2019, premiums were $2.1 billion. Direct losses paid.
Or not. We're hoping that
$1.278
pass and this bill fail
for a profit of 63.89%. 2020, premiums collected $2.135 billion, claims paid $1.202 billion, profit 77%. 2021, premiums collected $2.2 billion, claims paid $1.439 billion, profit 53%. 2022, premiums collected $2.3 billion, claims paid $1.9 billion, profit 20%. 2023, $2.5 billion collected in premiums, $1.977 billion paid, profit 29%. Any reason to dispute any of those numbers?
Senator Tucker, if you want to sit with me and file a bill about insurance companies and premiums and profits, I will happily co-sponsor a bill with you.
You do a lot of those, don't you?
I do a lot of that. In fact, I'm not the biggest fan. They're not my biggest fans, obviously. I have repeatedly I think that speaks to why I'm here sitting here with this bill. I have tread that ground. I understand that landscape. I have worked tirelessly for 14 years to attack prior authorization policy. I know this. And I understand this. That is a completely separate argument, and I appreciate you're conflating the issue because you're good at that, and you have a degree from Harvard. My degree is from Stone County, Arkansas. I'm just a rural girl from Arkansas. That's who I am.
So
I
Conduit
know
News has
math,
put out
and I know
argument
what's
regarding
equal,
this.
and I know what's fair, and I know what's balanced. And so I'm here to advocate for that principle because that's the principle of the people that I represent understand and acknowledge. And that's what we're trying to do with the bill. But I will sit with you and I will co-sponsor a bill all day long to try to get under
So
control
this is an
that
article
whole
by
entire
Conduit.
landscape.
You can listen to this while reading this. No. Yeah, let me pause from Tucker because he can get kind of boring. Let me go back to this and see what's going on here. Who is us? You don't speak for everybody. No, they don't. It reverses it. That means exactly nothing. No, it's not. And organizations do it all the time. This is a reverse racist, is what this is. Oh my goodness. Oh, wow. Oh my goodness. I don't think Moses said that. Moses said, "Let my people go." What have we got here?
Bill, I think one of the things we all agree on is nobody wants to discriminate or be discriminated against.
No,
I think
not everybody
equality
agrees that.
sounds excellent.
The black lady believes in
Equality
discrimination.
without a
Just
path
reverse it.
to achieve it is just not really the same thing. I
Who says you're
believe
the
that
path?
Arkansas has several laws on the books now that provide equal rights. But if people are not given the opportunities to achieve those rights, then it's not equal. Ensuring access is not a preference, and it is not. It does not offer
Nothing is
preferential
ever going to be
treatment.
good
It
enough for these
offers a
people.
path. It begins to pave the path for people who do not have those opportunities. Annabeth mentioned that
Let me
a
turn Kate's
statistic
camera
about
to other
women in
things to do.
college, and I've got a statistic about women in businesses. Women are the fastest growing business owners, and yet women get only 15% of the loans that they apply for. They generally start smaller because they're starting with their savings. Any kind of help that they receive is not taking away from anybody else. It's just ensuring that they're able to meet those goals. We've heard about the critical needs rather than DEI, but I haven't heard critical needs defined. Really, what we propose is that DEI meets critical needs. Currently in Arkansas, Arkansas ranks 47th in education attainment. I just wonder if more people had a path to higher education, not just the opportunity, but a path to get there and the tools they need to support them through that process, if we could move out of the bottom 10. We are ranked 4th highest in poverty in the United States. If more businesses had the support they need to succeed and could pay higher wages, could we improve that ranking? 47% of households in Arkansas are ALICE, which is asset limited, income constrained, employed. Many of them are employed in 2 or 3 jobs trying to make ends meet. If we could reach a place where we had fewer working poor, could we reduce that number? True equality to me means more than an opportunity or availability. It means that you have real access. You have real opportunity for individuals, families, communities, and regions. And I think that brings me to a final question of, I really don't understand how this bill would help achieve any of those goals. I don't understand the goals. I don't understand the statistics behind it, or the goals that this bill seeks to accomplish that would reduce any of those issues that we're currently facing. And I would appreciate a vote of no, and I appreciate the opportunity to speak. Thank you.
Thank you, Mrs. Temple. Looks like we have at least one question from the committee. Representative Rose, you're recognized.
Yes, thank you, Mr. Chair. Thank you for your testimony. You mentioned more opportunities for higher education.
Yes.
Am I interpreting that correctly? I was looking at some statistics, and I think it was in 2022, 22.2% of Arkansas women had bachelor's degrees compared to 20.8% of men. And this is from the Women's Foundation of Arkansas. So my question is, do you think that you need a greater sampling of women with bachelor's degrees over men, or do you think that where it stands now is actually a pretty good thing?
Well, I didn't mention women in the discussion about education. I just said that Arkansas ranks 47th, and that I think if more people had a path to higher education, I didn't say women in that. I think really assuming that everybody has the opportunity to go to college is not a good assumption, or that if they go with the same tools to succeed. I know people who have gone to college who are very smart, but they couldn't make it because they weren't prepared. I know people who have not gone to college that probably should have because they were smart, but they didn't have the tools to get there. We need more people going to college and graduating, men, women, Black, white, Hispanic. We need more people going to school. If we can ensure more people have the tools that they need to take advantage of the opportunities that equality should provide, then imagine what that would do to our economy. We might be 37th in educational attainment. We might be, not so high in poverty. We might drop our ALICE households considerably. We need the tools to help us achieve these opportunities. And I'll just be honest, my pastor quoted a tool that I wish I had had, and that's the amount women make now compared to men. It's always been that way. So we say this is, I listened to the last hearing, and it was repeatedly about equality. How is earning 74 cents to $1 or 78 or whatever it is, how is that equal? If you're merit hired and you're doing a good job, how is that equal? So to me, it's not about how many of what sex should be educated or in business or receive loans. It's that everybody should have the tools they need to get there and succeed.
So thank you. And I think you asked a question, and I don't have all the statistics, and I don't know the 74 cents or 78 cents on the dollar. I do know, I think women are in the workforce for an average of less time, predominantly due to giving birth, taking care of children, spending time at home. And so that would lend some credence if you've been in the workforce for 10 years versus 20 years. The person who's been in there 20 years on average is going to make more than the person who's been in the workforce for 10 years. That was just in response to the question. I guess the only other thing that I would make mention of is I think you and I both agree more opportunities for people to do better is great.
Yes.
I don't necessarily know that more people going to college is necessarily the best path. I think workforce development, trade schools.
I agree with that.
A lot
Trade
of things
schools,
we're seeing from the LEARNS Act and the direction the state's going may lead to even higher paying jobs. And I apologize for mischaracterizing the direction of your comments on higher ed. You had spoken about women. I thought those two were married together in that. But thank you for your testimony. I appreciate your time.
Thank you.
Thank you, Mr. Chair.
Representative Ray, you're recognized. We had you down as having a question.
Oh.
All right. Ms. Temple, thank you very much for your testimony. Appreciate you being here. You're excused.
Okay.
Next, we have Lance LeVar signed up to speak against the bill. Mr. LeVar, if you would state your name and any organization you're here representing, and then you'll be recognized to present your testimony.
Yes, my name's Lance LeVar. I'm speaking on my own behalf as a citizen. So I come to this having been employed by the Arkansas Department of Education in the office that was formerly known as the Equity Assistance Center, having been part of the group that helped write and monitor the Teacher Administrator Recruitment Retention Plan law, having taught districts about that and how to do that law throughout. And I will tell you that probably no reason that there is a question from the secretarial leave or concern is the Department of Education has basically been ignoring the legislative intent of that law for the last couple of years. They've avoided talking about diversity, equity, inclusion in there and focusing on minority people. They've even removed the minority report on colleges that are graduating, and instead just reporting on everybody that's graduating each semester. We've had these discussions, and so there are a couple points that I want to hit. So I'm giving you that to know my background. I left the Department of Education in July when the Office of the Secretary of Education would no longer allow the Department of Education, and specifically my role in office, to fulfill what you have asked us to do in this bill that's being adjusted, which is to provide guidance and support to schools on their civil rights duties. And specifically, we weren't able to do what was in the governor's executive order to provide guidance to the school districts on Title IX. When I was not allowed to help the school districts out anymore, I left and decided to do that directly on my own. I'm going to hit a couple points, and I'm more happy to take any questions that you have. It's interesting, they talked about DEI, and it was even mentioned at the helicopter and airplane accident that there's some accusation of that being DEI. I want to make sure you understand where this DEI from the federal government is going to, because in that same speech when President Trump said it was about DEI hired, he said, "Can you believe the FAA is hiring people with disabilities?" And I heard him, those are his words. And then he went on to disparage people with disabilities as not being able to work properly in the FAA. In the internal memos of the Defense Department, DEI adds the A, which is diversity, equity, inclusion, and accessibility. This is the beginning of where it continues to go. And I wanted to make sure you understand that, because I also do work with Section 504 in disability law. The Teacher Administrator Recruitment Retention Plan was very clear. Its purpose was to increase the opportunities and increase the diversity. And it's based off some specific ideas and details and statistics. You've got the majority of 96% of major employees want employees who are comfortable working with colleagues, customers, and/or clients from diverse cultural backgrounds. Negative effects associated with insufficient racial diversity extend to members of non-minority groups. White students in particular benefit broadly from the ethnic diversity aversive learning context. That's the American Psychology Association studies. Students develop improved civic attitudes toward democratic participation and result from diverse learning experiences. That's how racially diverse schools and classrooms can benefit all students, research and work. In Arkansas, there is not a single district that does not have a minority student. Yet there are a large percentage of students, of districts, that have no non-white teachers. That's why the Teacher Administrator Recruitment Retention Plan was about diversity. Students do better when they are exposed to diverse groups. Another thing that's been referenced is the study that states that a low-income black student with one or more male black teacher between the 3rd grade and 5th grade are 39% less likely to drop out and 29% more likely to pursue a 4-year degree. That law was necessary. And as the Department of Education has not fulfilled the intent of that law, we've also come to see that we have not decreased in our teacher shortage, but it has increased. And then the last point, I think I want to hit on this because you've heard a lot of stuff today, and I want to give time for anybody that wants to ask me a question, is understanding the difference between equity and equality. Simply put, equality is giving, example I give, equality is giving people a parking lot that we make sure there's enough parking spaces for everyone. Equity is ensuring that those who have struggled getting into the building have parking lots that are closer and access to ramps. Equality is saying, hey, this assignment was due on Wednesday. I know you were sick that day, but you should have found a way to turn it in. Equity is recognizing and giving that child a chance to turn it in later. Equality is about assuming that everything is equal to begin with, and equity is recognizing that there are barriers. Equality is saying, I worked hard for this, and holding to that only. Equity is acknowledging that I worked extremely hard for where I got, but recognizing that others had to work harder. That doesn't diminish my efforts, and it never has. But it helps me recognize and be humble to God for the privileges He has blessed me with, and my responsibility to use those privileges to help others. Equity is the prodigal son's father. Equality is his brother. I am more than happy to take any questions on the Teacher Administrator Recruitment Retention Plan or any of the other parts of the law, and that's the end of what I wanted to address immediately.
Thank you, Mr. LeVar. Are there any questions by the committee? Seeing none, thank you, Mr. LeVar, for your testimony. Next, we have signed up to speak against the bill, Deborah Halbert. If you would, state your name and any organization you're here representing, and you're recognized to present your testimony.
My name's Deborah Halbert, and I'm here representing myself. I want to clarify a couple of things about affirmative action and DEI programs that have not been discussed enough. First of all, these programs are not about hiring unqualified people because of their skin color. They simply are not. They're about teaching businesses about the added value that a diverse workforce brings to the business. Several database studies are available online by heavy hitters like Deloitte, McKinsey, and Harvard Business Review that have found many statistical benefits to having a diverse workforce. For example, diverse companies have a 32% increase in productivity, are 35% more profitable, and have a 68% improvement in employee retention. It is simply good business to recognize the value of a diverse workforce and management team. DEI and affirmative action programs teach businesses how a diverse workforce will benefit the business, how to expand application pools, how to foster an inclusive environment in order to increase retention, and how unconscious bias may be limiting hiring and promotions. Businesses care about the bottom line, and the data shows that diversity is a smart business move. Qualified employees with diverse backgrounds enrich a team's decision-making and innovation. That is an added value that the qualified person brings to the table. Recognizing that added value is the point. My hope is that those of you who support this bill did not realize that there is a measurable benefit in diverse perspectives and life experiences. Now that you know, I urge you to vote no on SB 3. Thank you.
Thank you, Ms. Halbert. Are there any questions by the committee for Ms. Halbert? Seeing none, thank you for your testimony. Next, we have signed up to speak against the bill, Dr. Gail Choate. If you would, please identify yourself for the record, stating the organization you're here representing, and you'll be recognized to present your testimony.
Thank you, Mr. Chair and committee. My name is Dr. Gail Choate. I'm here representing myself, and I need to maybe not explain because it might be obvious, but to point out that my testimony represents the breadth of my identity and my experiences. First of all, I'm here because I am a PhD. I hold a PhD in political science with specialties in political behavior and American government. I was at the Senate bill meeting. I was also had the opportunity to listen to testimony from the floor. And one of my major concerns was that during the debates that ensued around Senate Bill 3, there was no data presented that indicated the impact of the laws that are on the books today, nor looked at the unintended consequences of this bill. You're being handed right now by staff a white paper that I prepared for your review that addresses the role of affirmative action and DEI on our society in the areas of higher education, employment, and business, along with a list of references where this information came from. Overall, rather than reading this report to you word for word, I want to point out that my recommendation at this time as a scientist is that you do not have enough information about the both intended and unintended consequences of this bill and how it will impact Arkansans of all races, genders, and socioeconomic status. There are many pieces to this, and when the Representative Bentley presented, she indicated that her reason for running this bill was largely in response to the president issuing an executive order repealing affirmative action. While I do not argue that that was outside of the scope of his responsibilities nor privilege, I want to point you to the 10th Amendment of the United States Constitution that gives power to the states. The reason it does that is because the Constitution recognizes that states have variations and that states have a responsibility to look specifically at what is good for the citizenry within its states. Education, for example, is not a power that's afforded to the U.S. government. It is a power that is reserved to the states, and therefore you have a responsibility to understand how laws that you enact may impact the populations that have elected you. The paper that I presented to you points out a couple of things that I'd like to just make mention of. Number one, as has been testified earlier, DEI initiatives and affirmative action are not synonymous. They are often conflated, but they are not terms that represent the same information. Affirmative action was designed to increase minority representation. DEI is designed to give equal opportunity and to create an inclusive culture. Further, I'd like to just point out that SB 3 is broad language would eliminate DEI programs, which are not affirmative action, but rather efforts to create fairer workplaces, school, and public institutions. I'm going to take off my scientist PhD hat and I'm going to put on my mom hat because I am also a mother. I'm also a white woman with 4 children. And I thought I understood, much like Representative Bentley has explained, that that all children are afforded equal access and equal opportunity and the chance to be treated the same. My oldest child is my biological child. He looks just like me. He's got green eyes and white skin. My other 3 children are adopted, and they're Black children. When those children went into the school system in a very racially diverse part of this country, I very quickly understood that the experience that they were faced with in the classroom, in the admission to extracurricular programs, in the opportunity to participate in things like magnet programs, were not afforded to them equally. Their experience, even growing up in the very same home with the very same parents, were not the same for my 3 children. They were different. I believe very strongly as a mother and as a scientist, I present you with data that supports the idea that creating opportunity is a responsibility that we all must take. And you, as legislators, in voting no on SB 3, have the opportunity to consider the opportunities available to all Arkansans. I also just want to point out one other thing that I think is important. We often think that as representatives, we can talk to our individual constituencies, and perhaps they can tell us what they need. And while I am a firm believer in representative democracy, which says that you are here to listen to the voice of the people, and in fact, that Constitution claims that it is we, the people, who establish our government, oftentimes our districts, our territories, our constituencies are narrowly defined and therefore do not represent the state as a whole. I don't envy you because your job is to represent those people directly in your districts who elected you to office. But I ask you to also take on the mantle of what is good for Arkansans as a whole. Just to give you an example about the racial disparity that exists, if we were to only listen to the voices of the constituencies in Senate District 20, which is represented by the sponsors of this bill, we would be listening to an area that is 95% white, 2% Hispanic, and 0.8% Black. Yet, if we look at Arkansas as a whole, we have 15% Black, 7% Hispanic, and 73% white. Huh. Notice how I just conflated that. That was a Freudian slip. Sorry about that. But the idea that I want to point out is that we have to look at it on a broader picture. We sometimes think that offering or removing DEI, removing preferential treatment, will enable all people to benefit by their merit. But I'd like to point out another example. When affirmative action was removed from higher education, MIT reported the results of the change in that policy. And what they reported that was the removal of affirmative action reduced their Black population from 15% of their student body for a specific class to 5%. The Hispanic representation went from 16% to 11%. The white population, what do you think happened? It was reduced 1%. It went from 38 to 37%. How can that be? Because the Asian American population rose from 40 to 47%. I tell you that just to point out that there are unintended consequences that you may be unaware of. I urge you to look at the white paper that I presented to you. I urge you to vote no on this bill to allow the legislature to have the time to do the appropriate research, to understand what is truly needed by our community, and to understand the data that will support the decision and give us the best opportunity to weigh who will benefit from this legislation, if there is a benefit at all, or in fact, will it take us backwards? I thank you for your time, and I welcome any questions that you might have.
All right. Thank you, Mrs. Choate. Are there any questions by the...
It's Dr. Choate.
Dr. Choate, sorry about that. Representative Ray, you're recognized.
Thank you, Mr. Chairman. Dr. Choate, I guess I'm wondering about this chart that you created in your paper here on where you break down the percentages of various racial groups in Senate District 20.
Yes, sir.
What's the purpose of including that?
Because I think it was important, not so much in this committee, it didn't come up, but in the Senate committee and as well as on the floor debate, there was a lot of reference to the constituencies. And in fact, today when it was presented as well, part of the anecdotal information that was presented was from the constituencies of the sponsors of the bill. So I thought it was important for us to understand that perhaps those constituencies were not representative of the entire state.
Okay, you're not suggesting, though, that we shouldn't listen to Senator Sullivan's perspective on this because his district is not as representative as the state as a whole. That's not what you're suggesting, right?
No, I'm not suggesting that, sir. What I am suggesting, though, is that we have the previous people that have spoken have asked whether or not the lived experience of the Black population might be different than the lived experience of the white population. And we have, I think, pretty much heard a consistent, yes, there may be differences. So I think it's important for us to understand that those lived experiences may vary depending upon the overall makeup of the constituency in different areas.
Okay, thank you.
You're welcome. Thank you for asking.
All right, seeing no further questions, thank you very much.
Thank you for your time.
Next, we have signed up to speak against the bill, Marcela Garcia. If you would, identify yourself for the record and state any organization you're here representing. You'll be recognized to present your testimony.
Good morning, Mr. Chairman and members of the committee. Excuse me. My name is Maricela Garcia, and I'm with Arkansas Advocates for Children and Families. For more than 47 years, Arkansas Advocates has advocated for research-driven, proven policies that have improved the lives of children and families in Arkansas. I'm not here to talk about the morality issues of SB 3. Those issues are already very clear. As an attorney, I do want to talk about how this bill is poorly written and does not do what the sponsors think that it does. It's not drafted to comply with the Supreme Court decision that deals only with affirmative action in higher education admissions, nothing else. And it doesn't go, this bill goes well beyond that. Instead, it's also not it was not drafted to comply with any of the executive orders because this bill is the same as SB 73, except for it adds the provisions about veterans will not be affected. The bill is going to put the state and other entities in a very precarious position. When you look at Section 21, it's overly broad and it applies to not just state employment and public education and state procurement. It defines the state to include a city, a county, an institution of higher education, and a public school district, or a public special school district, or a political subdivision of a government instrumentality of the state. This means that all of those entities are subject to SB 3 because they all hire employees and procure services. This will create civil causes of action against those entities with a very low burden, meaning most cases that would be previously thrown out now will reach a like into the litigation phase as opposed to a pretrial phase, meaning the cost will increase to defend against such a lawsuit. This is not about a lawsuit if the law is constitutional or not. This is the lawsuits that the bill itself is going to allow people to have when they feel that their rights have been violated. That feel makes it so that they reach easily the initial stages of the lawsuit. Even if people are unable to recover attorney's fees and court costs at the stage of with the court, they're then referred to the commission, and it says they must award the fees. Again, there's not a decision on whether or not they should have the fees, whether the lawsuit was valid or invalid. It says must, and must means they have to do it. These costs are going to put cities, counties, and these other entities, including state agencies, in a very serious bind when you consider a lawsuit that costs maybe $3,000, but 100 of those in a year to these entities do not have a budget allocated for that, because the idea is that normally the state would be able to say sovereign immunity, this doesn't matter, but because we've lowered the burden so far, these people are going to get further with their case than they normally would. You can expect these suits to be anywhere from thousands of dollars to hundreds, tens of thousands of dollars to hundreds of thousands of dollars, depending on how long these cases take and how they're drawn out. Not only are the agencies going to be put in constant threat of jeopardy of litigation, but again, it's an exorbitant amount of money you can expect to be impacted here. And, if we consider maybe 30 of these lawsuits, we're reaching $100,000 right there. If these lawsuits are not easily disposed of, and they won't be because of the low burden, the costs easily are going to reach higher. The bill is convoluted. It puts together lots of different things under the assumption of equality, but it doesn't actually do anything, bring forward any new program or amend any program to make equality happen. So we've heard the difference of equity and equality, but again, even though the bill says it strives for equality, it doesn't put forward anything that will, in fact, achieve that. It's overly broad and likely to harm not only children and families, government workers, the administration of government, localities, counties, and the state itself. And for these reasons, we would urge you to vote no on SB 3. Thank you.
Thank you, Ms. Garcia. It looks like we have some questions of the committee. Representative Clowney, you're recognized.
Thank you, Mr. Chair. Thank you for your testimony. Just a very quick question. So the question was asked earlier, will not passing this bill put Arkansas at risk of a lawsuit because of the Supreme Court ruling? I guess my question to you is, do you see passing this bill, this overly broad bill, as you say, as putting Arkansas at a higher risk?
Yes.
Thank you.
Representative Mayberry, you're recognized.
Thank you, Mr. Chair. And really, it was the gentleman probably two before you that brought this up, but you kind of are mentioning the equity and equality part of this. And so I thought maybe I'd ask you, even though the other gentleman brought it up, how would something like this affect a student who has a 504 plan in school? Since that's a federal 504 plan, does this change anything? Do they have the same protections in the school? Like he gave the specific example of, extra time on a test. Does this change that in any way? Do you see that?
I think there's the potential because schools are more likely to be cautious in how they approach any kind of extra access, right? Because that will potentially give someone else the opportunity to say, well, I didn't get extra minutes and that was unfair. So my rights have been, a parent can say my student's rights were violated. So I think that what we will see is that people will self-censor, and that in and of itself becomes like a bigger issue. Yes.
Even though it is federal law that they would be under.
Because you're never going to get a real answer. They'll always try to look and find.
You're talking about what would an injured person, how many attorneys would they need to hire?
Right.
Well, you'd hope they wouldn't have to hire anybody.
But they do.
But to navigate it, they generally do have to hire an attorney.
Yeah. The system's so complicated.
They wouldn't have to hire anybody to get justice?
They shouldn't have to hire anyone to get justice. They shouldn't have to.
Right.
But they do.
But they will.
They will. And they do it on a contingency fee because most people are not going to be able to pay, particularly while they're not working. They're not going to be able to pay an attorney to do what they need to do, to get done.
So
and these days, the attorney's not just dealing with the insurance company. They're dealing also with the health insurance company. They're juggling a lot of those negotiations.
So in order to get that justice, there's a possibility they would have to hire numerous lawyers.
It's possible, but it depends. It depends on the scale of the case or who's refusing to do what. But no one, I can assure you that first of all, no one wants to file a lawsuit that's ever sat in a chair in my office. And of the people that experienced it, never want to experience it again. Not pleasant.
Do you know why the governor of Louisiana vetoed that bill?
Because he said it was just a simple handout to the insurance companies.
Yeah. That's it, Mr. Chairman. That's all I have.
Other questions from the committee? Seeing none, thank you, Mr. Boyd.
Thank you.
For your testimony. Mr. Allen, I just want to confirm, because you're on the list, because you are 4, so we'd go to 4s after the, and you're good. Okay, so we're going to go to Beth Wyatt.
But I need something from you. Yeah. Okay, thanks.
So this is the HB 1204. It's basically a bailout for insurance companies. It gives them a cap on how much you can get. And the biggest problem is it doesn't punish the insurance companies for when they make a mistake, when they claim someone's dead or they mess up someone's paperwork.
Ms. White, would you make sure your mic is on and state for the record your name, where you're from, and who you represent?
Sure, thank you. My name is Elizabeth Wyatt. Call me Beth. I'm sitting up as tall as I can. I'm sorry. I'm from Arkadelphia.
Okay. You may proceed.
Thank you. Thank you for all being here. I'm a little bit nervous. I am a retired educator.
Bill, while I do some more.
And I've been sitting here all morning listening, and it's been very interesting. But I would like to give you a real scenario, real life. We heard a lot of what ifs. We heard a couple, and I'm sorry about your grandson's wreck. We've heard a couple of people, but I'm living it right now. So let's put this dog and pony show to work. I'm a retired educator working 16 years in Arkadelphia Public Schools, or in Arkansas Public Schools. I worked 8 years at our local education cooperative, Dawson Co-op. I worked 1 year as a literacy coach at Interamericano in Guatemala City, Guatemala. And my last position was as a professor of reading at Henderson State University. I am now a professor emeritus at Henderson State University. Still have an office. It's kind of nice. On July 5th, 2022, I was in a head-on, I was hit head-on a mile from my home. I was driving on Arkansas Highway 67. The young man, Jesus Vasquez Garcia, was a recent graduate of Henderson State University on his way to turn in his used textbooks. There were no drugs involved. It was 2:30 in the afternoon.
Can you bring the mic any closer?
Yes. Is that good?
Yes, I think so.
He went to Henderson to return his used library books or his used books. Straight away, no curves, beautiful day, no texting involved. It was just a simple accident. He spent a week in the hospital, and now he's at Hendrix. He's going to graduate soon with a master's in business. He was considered an excluded driver, even though he paid the driving insurance. And I had to fight to get the $25,000 minimum. He also had to pay a fine of $315. It would have been more if I had died. But I was too stubborn, and it was $315. And it was that high because I refused to drop the driving left of center charge. He's now done with this accident, completely done with it. His journey is over. After the event, I ended up less than 50 feet from a fenced off power gas line. I was 50 feet off the road, hugging a tree. My car was against a tree. I was trapped in my vehicle. While it was on fire, I was screaming at the bystanders, one of whom I'd gone to high school with. And he said he was terrified because he was watching his friend die. And I was screaming, please don't let me burn. The obvious injuries are my loss of both legs. I had 2 amputations on each leg. So that was 4. They did above knee after the below knee failed. I have 2nd and 3rd degree burns from my hairline down to where my knee should be. The loss of one eye. I have a TBI, which includes 2 brain bleeds and a concussion. I have limited use of my left arm, limited use of both hands. I've lost a spleen. I have recently found out that I have 3 chronic illnesses: amputation, burn, and the loss of a spleen, because I have to continually monitor my progress with those 3 things. I had many internal injuries. I had pneumonia on both lungs twice. I had grafting 3 different times because the first 2 grafts failed. Fortunately, because I was a teacher in Arkansas, I had very good insurance. The insurance company was good, and my lawyer, of course, fought very hard for me. However, I did have to fight to get my $25,000 from Texas Insurance. They are the insurance that insured Jesus Vasquez Garcia. The truth is, if the insurance company had done the right thing, I wouldn't have needed my fabulous lawyer. I've never sued anyone. I didn't want to sue Jesus. The insurance company, if they had done the right thing, I wouldn't have needed to bother with it. This wasn't some greedy lawyer that I hired. He didn't come to me. I came to him. I didn't want somebody who did this every day for a living necessarily. I wanted someone who would fight. And he did fight. He fought against Trexus, a multi-billion-dollar behemoth who didn't want to pay me $25,000. They knew they owed me, and all this time, I was fighting for my life. I had the option of continuing a lawsuit to help cover lost wages, much like your bill is insinuating I will have to do. I had that option, but excuse me, but Jesus Vasquez Garcia had nothing. He was a student. His mother cooks on an outdoor pit in the backyard. And at the time, honestly, I was more interested in living. You see, when I went to the hospital, I had a blood pressure of 40. That's it, 40. I didn't need the hassle of having to fight another battle. One that I didn't cause, one that I didn't ask for, but one that severely changed my life and my family's lives and my friends' lives. Like many other Arkansans, I was pretty powerless. Anyway, just having to accept the minimum amount of insurance the faulty party carried. Again, once I signed off on that $25,000, he was done. His journey is over. Mine continued. I was flown to UAMS where I spent 17 days in ICU, and the doctor's notes mentioned imminent demise more than once. I was then transferred to Children's Hospital for 67 days in the burn unit, after which I moved to Baptist Health and Rehabilitation for 14 more days. You see, I spent 67 days in an ICU setting. My bill from the first 48 hours was over $500,000 and about 1,000 pages of doctor's notes. I had 19 surgeries before I went to Baptist Rehab, 4 surgeries after rehab, 3 sets of prosthetics, a manual wheelchair, an electric wheelchair, a shower bench, a new refrigerator. I had to get a side-by-side because I couldn't reach above here. And I'm getting a new stove because the handles are all in the back. Things you don't think about when you're whole. We had to leave our home for an apartment, and I'm in the process of, again, purchasing the new stove. I had to take doors out of my closet so I could get into my closet. We even had to buy a chair. We didn't have to. I mean, my husband could have been stronger backed. But as a paramedic, his back is shot. So he had to buy a chair that goes in my car, and it turns and comes out and goes down to wheelchair level. So he doesn't have to pick me up to put me in the car when I can't wear my legs. I tell you all of this not because this bill will impact me today. It won't. And I'm hoping you will understand the outcomes of someone doing the right thing. I worked for over 40 years as a teacher and loved it. And I loved working at Henderson, teaching pre-service teachers how to teach reading. To see them look at the child's eyes when they're teaching them to read for the first time, and they're in my class, and I'm watching them teach a child, and the child's face lights up, and their face lights up, and my face lights up. I'm not doing it. 40 years of teaching and following the laws, except for one speeding ticket. Jesus Vasquez Garcia hit me, and he had insurance. He was paying for himself. but his dad had him listed as an excluded driver. He was 21 years of age, I believe, at the time. He had been an excluded driver since he was 16. He had no idea that he was an excluded driver. He had gotten tickets while being an excluded driver. He purchased his vehicle. He had to have proof of insurance. I hope I'm making this more real and understandable for you and for the people who aren't lawyers. When I heard about this bill, I started researching. It's not a new tort we need. It's insurance reform. Legislation doesn't work for this. Not anything that helps insurance companies while making it harder for me or you and all of your other constituents. Makes it harder. These battles are not easy to fight. It's an uphill battle. This bill makes it even harder on people who find themselves in horrible situations at no fault of their own, kind of like me. Any personal injury can be horrendous, no matter how it happens. But to have to face trying to get the other party to pay is insulting and exhausting. And that's what this bill is asking me to do, is use my hard-earned money in insurance to pay for my illness. The statute of limitations on my case was 3 years. It's been 2.5. 10 months of those 2 years were taken up by Trexas Insurance, using every kind of sophisticated delay tactic possible to get out of paying what we all knew they owed. It was enough to bring me and my family and my friends to tears and at times insanity. It truly was adding insult to injury. But my story, my journey is still not done. Jesus's is. His ended 10 months after. Mine's still ongoing. I was in rehab for 2 years. I was not strong enough to have faced a trial. As you can see right now, I'm having trouble facing you all. And this isn't supposed to be stressful. I didn't have time to get a case together. This is exactly the scenario House Bill 1204 is proposing. As a survivor, you see, I'm not a victim. I refuse to be called a victim. I'm a survivor. I can tell you this is a huge problem. I have ongoing expenses, and I will have for the rest of my life, that are all due to an incident that I had no control over. This bill punishes victims over and over again by making us go to court, whether it's one lawyer or 14. It's punishment. I promise as the law exists now, it is hard enough on victims or survivors. This change truly hurts them even more. As I was listening, the insurance company kept talking about I could get reimbursed. You'll get reimbursed for all of your expenses. I haven't been reimbursed for anything. The 90 days that my husband drove up to Little Rock, every single day, he couldn't stay with me because it was COVID. Every day he drove to the hospital, sat in the waiting room at UAMS to find out if I was alive that day or not. Before I even left the hospital, I got a bill. I wasn't even awake to know it. I was lucky enough to have a husband, someone to help me. You see, I was out for 40 days. If you're familiar with the Bible, 40 is a magic number. Was for Noah. 41 came. And I don't know why God chose me. But I want to do all I can to help the people like me, the little man, literally and figuratively. I want to help us, those of us who work hard, who pay our taxes, who pay extra for insurance. In closing, I would like to thank all of you for listening. I've never been political, except within our family, or I've never testified for or against a bill. This is all new to me, and I likely never will again. But I'm here because I want to help you see past the lobbyists and the talking points of the real-life results of this legislation. All I heard this morning was that it would benefit doctors, hospitals, and insurance companies. It would cause me to go to court many times over. You see, my husband had to retire after this as well. He can't face being a paramedic anymore. I had to retire because of this. I lost wages. I can't run after my grandchildren. All my granddaughter asked for this year for her birthday was for me to wear my legs so I could run after her. We walked around the yard. You see, my journey isn't over. It didn't end 10 months later with that $25,000 check. I'm just now able to get up in the morning and look in the mirror and not think of Jesus Vasquez Garcia. I pray for him every night. I pray that he is successful and that he has a good life. And I pray that he stays healthy. It wasn't his fault this happened. But he should be the one held accountable. Trexas should be the ones held accountable. Not me. Because I'm not a billion-dollar corporation. I'm a retired teacher who's married to a retired paramedic. Two people in this world you cannot do without. I hope you'll remember me and what I've said and the real life results. And you'll think about me and the people back home and your wife, your daughter, your husband. And I hope you trust. We can trust you to do what's right for us, the little people. Thank you. Do you have a question?
Questions from the committee?
I'm sorry, that was a teacher in me.
Ms. Wyatt?
Mm-hmm.
Do you know what your total health care costs have been up till now? Or close, an estimate?
3-4 million.
3-4 million?
Mm-hmm.
Do you know whether that is, and I understand if you don't know, do you know whether that is retail or what the insurance actually paid?
That's the bills we've gotten. We are in charge of.
I'm sorry?
We're in charge of all of that now. That's what we got on the bills.
Okay, but you
$4,000
have health insurance, right?
Yes, I have very good health insurance.
Yes, and so do you know if that's what they paid or they paid less?
I don't know what they paid. No,
Okay,
sir.
all right. Thank you. Any other questions from the committee? Senator Stubblefield.
Thank you, Mr. Chairman. Ma'am, you didn't want to sue.
Mm-mm.
You didn't want to hire an attorney.
Mm-mm.
You spent a whole year fighting an insurance company for $25,000.
Mm-hmm.
That what I heard?
Yes. Yes, sir.
And part of your premium paid went for a discount for the boy that hit you?
I have no idea.
Okay.
I don't know. I was not.
I thought that was part of the, is that true?
I'm looking at my husband because I was not mentally able to do it.
Okay. But part of, there was a discount paid to the boy that caused, okay, all right, that's all I want to know. Thank you, Mr. Chairman.
And out of the 25,000 you received, you paid your attorney?
Yes. And whatever else it didn't touch the bills, but we paid what we could.
Of course not.
What little we could.
Okay. Any other questions from the committee? Thank you, Ms. Watt, for your
Thank you.
testimony. Next, we have Denise Hoggard. Yes, everybody else is against. Since Justin Allen didn't testify, everybody's against. Let's testify. Ms. Watt, while Denise is coming, appreciate you being here today. I had other victims that contacted me and I asked them to come and they didn't, to show us what can happen and how your life is, regardless of money, how your life is disrupted, and not just disrupted, totally changed. So thank you for being here. Ms. Hoggard, would you like to, and whether you like to or not, would you please give us your name, where you're from, and who you represent for the record?
I'm Denise Hoggard, and I have had the opportunity to read about your biographies and know you, and some of you I know personally. You haven't had that opportunity to know about me. I am a lawyer for 41 years. I've represented both plaintiffs and defendants. I currently am employed at Rainwater, Holt & Sexton. I'm the past president of the Arkansas Bar Association. I'm also, probably unique in this room, a former member of the State Bar of Texas Board of Trustees. I am a current licensed Texas lawyer. I have spent my career advocating, or as my calling, to speak for those who can't speak for themselves. So my role has been to speak for Beth, or people injured who don't have the ability to have a lobbying effort or hourly paid lawyers to speak for them, but they need a voice. And it's my responsibility to speak for them with all my might, and to do that for their best interest, not mine. I want to tell you that when this bill was first filed, I was sitting bedside of my father, who was in the Baptist Spring Hill, and kudos for the health care he received there. He was there for a post-surgery heart attack. We were able, after several days, to get him well enough to take him to the VA, where he is now in a rehabilitation hospital, and I get the pleasure of sitting with him bedside there. And I was struck when this bill was passed by how different this would look for my father if he'd been injured by negligence, which he wasn't. He got great care. He's a 92-year-old Vietnam veteran who served in Korea as well. What this bill would do is, if he was injured by someone's negligence, it would mean that the insurance company representing the wrongdoer would get the benefit of the fact that my father has Medicare, he has a Medicare supplement he pays for, he has TRICARE, and he has access to the VA. That was because of his sacrifice. That was because he put his life at risk for his country. And the benefit of the discount that he may have earned by making prudent decisions and personal sacrifice would it be transferred from him under this bill? As I sat there and looked at my dad's circumstance and thought about clients, I thought about the average cases that come through. And Senator Rice, to your point, an average case that I look at is about $20,000 in medical bills. So what happens in a negotiation now with the insurance company when there's $20,000 worth of medical bills? Well, if you used the multiplier that we heard at House Judiciary of 2.5%, or 2.5 times, that means that the amount of the value of that claim, Senator Rice, if you'd been hurt by someone either through their intentional or their negligent conduct, would be $50,000. If, however, you had private health insurance that you paid the freight for, the value of the case, assuming $6,000 was what was actually paid, would be $15,000. And so if you had to hire an attorney for $15,000 recovery, you would get $10,000, which restores you for your $6,000, yes, and gives you a $4,000 pain and suffering and other expense recoup. It's all it gives you. And that's assuming that your insurance company paid $6,000. If you look at Medicare, then the likely amount that would have been paid is less. So it would have been $2,000 or $1,000. Medicaid, Medicare, those numbers are going to be somewhere in that range. And so if we applied the same multiplier, which is what the insurance industry does, that is not affected by what you do here today, then your recovery would have been, let's be generous and say 2,000 times 2.5. And then you would owe back the amount that was paid by Medicare on your behalf, because subrogation is not a rarity. It is a legal right that Medicare has, Medicaid, the VA, federal insurance, health insurance has, ERISA, employer plans have. Those things all have to be repaid out of what you're ultimately able to recoup. For a $20,000 case now, $20,000 in medical bills, for which $1,000 or $2,000 or $6,000 are paid, it may in fact be economically infeasible for you to hire a lawyer and go through the additional expense and time to await a fair determination of your injuries by a jury. That's the reality of the practice. So whenever I was listening to Senator Ervin, who I've worked with on sex trafficking cases and have abundant respect for, she talked about the balance of the scales of justice, and she talked about that ancient symbol. And so I wanted to touch on that a little. If you put injured Arkansans on one side of that scale, and the other side of that scale you're trying to balance, the insurance company by this bill is putting their thumb on that scale and tilting it more in their favor, because whether they should or not, they make offers based on the medical expenses. And if the medical expenses are discounted by Arkansans' hard work and prudence and personal sacrifice, that insurance company is getting the benefit. So I look at that and say, you know, I can see who gets hurt by this bill. I can see Beth. I can see the others injured. Who gets helped? Where's the money go? It goes to the pockets of the insurance company. What do we get in exchange? We don't get anything. They were here today telling you, and they've told House Judiciary, they can't tell you it's going to reduce any insurance rate at all. In fact, Senator Clark, you were concerned about the high cost of health insurance. This won't have any impact on the cost of health insurance. If anything, in a macroeconomic setting, it might, they say, impact the overall cost of milk. It's not going to change the insurance rates. Now, how did those insurance rates that are going to ultimately pay the bill for injuries get set? There's not a standardized medical expense list that I can go to tell you this is what an MRI ought to cost. But I can tell you that nationwide and by region and by state, insurance companies calculate that because they set premiums that will result in them being profitable. It's the only way you get to an $88 billion profitable industry is if you properly rate what it costs. So they have already calculated and baked into their rate that 100% of what medical charges are, because that's what is real and consistent. It's going to vary about whether or not you've been prudent and whether or not you have benevolence extended to you. But the insurance company has considered it and factored it in at 100%. So out of that $20,000 medical expense, and we only paid $6,000, the $14,000 just went back into the insurance company's pocket, and they've already been paid the premium for it. They get a benefit. I also listened about the timing on when this became the law that we could put in the full amount. And Mr. Allen talked about the Montgomery Ward case, and I think Senator Irving did as well. And I want to talk about the Montgomery Ward case, but also a little bit history before that. Because in fact, this does start before that. This is a common law concept, collateral source. It means that no one in setting the damages as a juror should consider what's available to pay those damages, whether it's the insurance company of the defendant or the health insurance that paid for the medical expenses. The collateral source rule says the jury's got to be kept in the dark about that. They don't get to know. And it is true that this bill won't change that the jury would get to know about insurance, because I can tell you, insurance companies do not want you to know as a juror that there's insurance available to pay the bill. The insurance company protects that information. What's going to happen is that the jury's going to see the number of just what was discounted, and that's what they're going to think is the seriousness of the injury. So if you got injured significantly, but your bills are almost nothing, then the jury is going to be left with that impression that you have a small injury for which there is not much damage. So the Montgomery Ward case, 1998, yes, I want to tell you what the court said in that case, because you haven't heard that. The court said, if there is any windfall, and I've heard Mr. Allen talk about that windfall, it belongs to the credit of the injured person and not to the benefit of the wrongdoer. That's the policy behind the collateral source and behind the decision that was made in Montgomery Ward. We are reversing with this bill the result that says wrongdoers should not get a benefit, and we're giving it to them. Now, this doesn't just apply to car wreck cases. It also applies to those types of cases where others are injured by criminal action or by negligence outside of a vehicle, a car vehicle wreck. One of those things that comes to mind is y'all passed a civil felony rule. So I can sue folks when they commit a rape or a violent crime. I can go get those damages and make my clients whole. Sex trafficking is the same way, and I share Senator Irvin's passion about those cases. I was on the trial team that tried the very first sex trafficking case in Arkansas to a jury. And I can tell you that there's a twofold purpose to the remedy of torts. And the first one is to make the victim whole, the survivor whole, pay them back for what they were hurt. But there's also a deterrent effect that the wrongdoer gets no benefit, that he's held to full accountability, and that others who see what happened know to change their behaviors. Reducing the overall recovery for injury victims and sex trafficking survivors hurts our ability to affect the deterrence that the law seeks to impose. We lose that. These are significant losses from the bill that aren't talked about. I want to talk just briefly about Texas. Since I'm a Texas lawyer, I know that the impact of the bill that they passed is the most similar to the one being proposed here today. And what it has caused is that there are more lawsuits, there are more trials, there are more expenses borne by the injured person. You heard about the life care plan. I just wrote a check for a life care plan that cost $22,000. I can't recover that $22,000 from my client. I don't get to list that as one of the costs. But it's the reality of what happens when this bill is passed. Injured people have to wait longer, they have to pay more, and they get less. And in exchange, you don't get what you hope for, which are lower rates. If we're going to change a bedrock or an ancient symbol or an ancient rule in law, shouldn't we know by study, by data, by information that we can look at and trust that it'll make an impact? In this case, we are giving up without getting thing in return, and it's going to hurt the injured person. It also hurts our ability to bargain with insurance companies. They don't come to the table because they want to pay me a lot of money. They want to try to find out how not to pay.
Ms. Hoggard, I hate to interrupt, but I need to recognize Senator Rice.
Yes, sir.
Mr. Chair, I'm trying to be patient. With the test, I think you said one more. We have to testify. I hate to cut them short, but we're abusing time a little bit. We're going to have time to vote and get in session at 1:30. So I would just ask the presenter to wrap up if possible.
Yes, I will. Thank you. This is a Goliath and David situation. In this case, the injured folks are David. We have very few tools to fight back against a behemoth insurance industry. And this takes away a tool that is important to us in being able to negotiate and get fair results for our clients without making them all go through a jury trial and spend the years and the money to do so. Thank you so much for your time, Senators.
Any questions from the committee? Ms. Hoggard, it is your opinion that the Texas law has hurt victims?
Yes, sir.
Substantially?
Yes, sir.
All right. Any other questions? Hearing none, thank you for your testimony. Courtney, tell me how to pronounce the last name.
Roldan.
Roldan, that's what I would have guessed. Would you please
all right, folks, Courtney
recognize
Roldan,
yourself?
conservative, is now speaking.
Your name, where you're from, and who you represent.
My name is Courtney Roldan. I'm from Cabot, and I represent myself and my kids.
Okay. You may proceed.
So I'm here today not as a lobbyist or someone with special interests, but as a parent and an Arkansan who believes in fairness that we've talked about. HB 1204 is a dangerous bill that protects those who cause harm while leaving innocent people like you and me and our families to pay the price. Right now, if someone is injured due to negligence, they can hold the responsible party accountable. This bill changes that, letting businesses and individuals use your insurance against you to reduce what they owe. This bill allows a reckless driver, a negligent nursing home, or an unsafe daycare to get off easy because you had insurance. That's not justice, that's a loophole. I won't claim to be an expert on tort reform, insurance, or lawsuits. I'm just a mom who stays home with 2 kids. So I don't know how many questions I can answer, but just sitting here in this room, a couple of things have been made clear. One is that this bill is not representative of the people that you are elected to represent. This is for hospitals and insurance companies, and it may be the insurance companies' billing practices or the hospital's billing practices that need the reform, probably. There's no doubt that HB 1204 puts profits over people, so I ask you please to vote no. And I know it's been asked about Texas, and someone that's watching at home did send me this, and it says that the bill was passed in 2003. And between 2003 and 2004, health insurance premiums increased by 11.2%. In Dallas, homeowners insurance premiums increased by 460% in the 10 years since they've passed this. Also in Texas, the homeowners premiums have increased by 54.5% over the last 5 years. So that's the answer on if it's been affected by this bill. So thank you for allowing me to speak.
Thank you. Any questions from the committee? Ms. Roldan, thank you for being here. That is the last of our witnesses.
I don't know if they're going to go to the
So
vote or not.
if the sponsors would like to return to the table.
They go see what's going on in the other committee. They're going to do a closing statement. Or this may have already ended. Oh, this is SB3. So SB3 is apparently already ended. But let me see how this is going.
Seeing none, you, Senator Irvin, Representative Eubanks, shall recognize to close for your bill.
Thank you, Mr. Chair. Since you said that we get points for brevity, I'll be brief.
You do.
Okay, hope I get points. Ms. Hoggard actually said it very succinctly. Data and information that we can look at and we can trust is important. That's what the bill is about. It's about data and information that we can look at, verify, and trust. It's a receipt of what was paid, which should be actual damages, and then what is recovered. Again, I just go back to the simple principle of fairness and balance. Let's start there. And I would again say that all those other categories are preserved as they should be. The bill simply looks at actual damages, actual medical damages that were incurred, paid. The data and the information that we can trust is what's written and what actually was exchanged monetarily. That's what should be recovered under this one category for damages. And with that, Mr. Chair, I want to thank you for your time. I want to thank the members of this committee for their time. I also want to thank all the people that testified for and against this bill. It's been a long day, and I just ask for a good vote. Thank you.
What are the wishes of the committee? Motion to pass. Motion by Senator Johnson, second by Senator Gilmore. Any discussion? Senator Tucker.
Thank you, Mr. Chair. I took a lot of time. I'll be brief. Just a couple quick points. First point is, if this bill passes, costs are not going down. It doesn't even pretend to address healthcare costs. Health insurance carriers are not going to pay less. This bill doesn't address that. The only even theory that where costs might go down is on liability insurance carriers. And as I mentioned, over the last 5 years in Arkansas, private passenger auto, they've collected $3.5 billion in profit, not in premiums, in profit. And then commercial auto, it's another $900 million, $4.5 billion in Arkansas alone over the last 5 years. We're basic, and the benefits to the people of Arkansas that they're talking about are only through these insurance costs, if you're talking about the macro level. And if this bill passes, we're basically counting on the insurance carriers to operate like Ebenezer Scrooge after he sees the ghost of Christmas future. I mean, that's what we're counting on. That's what we're hoping for if this bill passes. I don't think it's realistic. Either that costs will go down or that they won't be raised by as much. I mean, think about who we're dealing with here. The second point is, I think it's glossed over. It's been made, but we're dealing with people who have done wrong. If they haven't done wrong, this bill does not affect, paying someone else's health care coverage does not affect them in any way. And this bill, you can argue that the scales are imbalanced now, but unquestionably, it changes away from people who have been injured through no fault of their own in favor of the people who injured them, and ultimately to the people who injured them, insurance carriers. That's what the bill does functionally. Now, you can argue there's a good reason for that. That's what the sponsors do, but that's what it does. And then the third and final point is, it's really a question of, who do we represent? Is the real question for me. I don't begrudge Mr. Allen for coming to advocate for this bill. He's doing a job, and he's good at it. He's very good at it. I like Mr. Allen a lot. But at the end of the day, it's up to us to determine whether the people he's working for, whoever that may be, they get the benefit of the laws that we pass, or other people who don't have a lobbyist here to advocate for them.
For this bill.
And on the one hand, you've got the liability insurance carriers, and on the other hand, you have Beth Wyatt and people like her who live in every single one of our districts. So at the end of the day, the buck stops with us as to who the winners and losers of bills are. And for me, it's going to be Beth Wyatt, so I'll be voting against.
Anyone else? Senator Dees.
Thank you, Mr. Chair. I appreciate the discussion. This was healthy for me. As this is, to me, I think when I'm listening to both sides of this bill, for and against, it was healthy for me to contemplate today and through the last week, really. And I'm trying to put into words my feeling or the description here. And I think this bill, it's 4 sentences long, and it describes how to think about the medical damages. And to me, that seems pretty clear. I know that there's lots of conversations around it, making sure that it doesn't do some unintended consequences. But I think there's a larger debate that needs to be had around the multipliers and the way we come to our decisions in the court system that have nothing to do with actually what this bill does. And I think we do need to address those at another time. But I think this highlights that there probably has been an issue. There's been an issue, and I don't think calling it lazy is the right way to describe it, but there's just been a history, a tradition of how we come up with the damages and the pain and suffering formulas. And I think that's been kind of the air around this bill, but not necessarily about the bill itself. And so in a 4-sentence bill that's gotten a lot of discussion, I have no issues with insurance companies making a profit. I think they should. And in fact, the ways that they don't make profits is because there's more accidents that they're paying out. We don't want them to be hurt in the profits. That means more accidents happening in a lot of ways. And so to call that out as an issue, I stand against. Just like I would stand against, I don't think there's an issue with lawyers providing great service to make profits as well. And so I think those are kind of mute. But what I find struggle with is the scare tactics that have been done about what this bill would do. And so after hearing all those things, I'm actually encouraged to understand that this is actually a pretty limited bill in the 4 sentences that it does. And it talks very clearly about damages only around billed versus paid medical damages. And so I actually feel much better about the limiting scope of this bill. And I appreciate the discussion today. Thank you, Mr. Chair.
Other discussion? Senator Johnson?
You know, I learned something every time I sit at this table or that chair, and you know, through this thing, it's not just, you know, this process, but I wish, I mean, truth and transparency and medical billing is something that's hadn't been discussed. And, you know, if you charge me $1, then that's what should be paid, and not have to try to cover what, you know, what is needed by the physician or any other medical provider by having to increase your bill to get covered what's needed. And you know, that's totally not part of this, but I think it would solve, I mean, this discrepancy
Eventually
that
they
we're
will
trying
take
to
a vote.
fix
So at least I'll
is
get this vote on record.
in this deal. And I appreciate everybody that came, and I appreciate the discussion. Thank you, Mr. Chair.
Other discussion? Seeing none, we're going to vote. I'm not asking you to vote extra loud, but I don't like to put my thumb on the scale, so I'm going to try to call it exactly as I hear it. So please vote loud enough that I can hear you. Okay. All those, we have a motion of due pass on House Bill 1204. All those in favor say aye.
Aye.
All those against? No. The bill passes. Congratulations.
Thank you, Mr. Chair. Thank you, members of the committee.
We're not going to do a roll call vote. It's likely going to pass in the full House.
I appreciate y'all. I know you'll eat at some point, but doing without lunch. We have some bills on the list, but I don't see any reason that we need to meet Monday,
well,
so we'll see you back here at 10 o'clock Wednesday.
This was hammered through by big insurance, and
thank you.
They
Nothing after session, nothing Monday, just meeting next Wednesday.
Meet next Wednesday.
get that done. I don't know about SB3. We can play what happened with SB3 here. Now, this was earlier, so I don't know, but I think it passed. We're going to call. So that's one way liberals try to attack a conservative bill is call it controversial. But when they put something, it's just for the people. That's what they always characterize things. DEI isn't about merit. It's just about choosing people based upon other factors. I'm going to pass by him. Let me take care of it. Oh.
know that I listened to their concerns. And I can't inadvertently just vote for this whole big thing and have that one little thing change. I'm sorry. I'm sorry.
Representative Bennett, you're recognized.
Thank you, Mr. Chair. I won't belabor this. I have a hard time with this bill. The sponsors who do not share some of the same experiences that this bill will affect. I have a hard time listening to you all saying what is best for people that don't have the same experiences. And I want to thank all of my constituents and all the people in the state of Arkansas who reached out to me to vote no on this bill. Nobody can make me understand these things. We do live in a racial society. Until you have walked in my shoes, in the shoes of my husband, who's a 25-year vet, my son who have disabilities, my mom, and all the people that came before me, you cannot sit there and the Senate sponsor sit there and tell me that this is needed. Thank you.
Seeing no further discussion, we have a motion on the floor of due pass on Senate Bill 3. All those in favor, say aye. Aye. All those opposed? No. The ayes have it. Congratulations, Representative Bentley. You've passed your bill. And with that, we have several bills by Representative Ray that are still on the agenda. We're going to come back this afternoon and take up those bills, likely 15 minutes upon adjournment. So with that, we will be adjourned until 15 minutes after adjournment, or recessed, I should say, until 15 minutes after adjournment of the House. Thank you all very much.
Actually, I kind of missed the vote on SB 3, so let me see how it fared here.
I am. And I need time to we're referring to, but I don't think it applies to the same thing. So again, maybe I'm reading way too much into this, but I need to feel confident that this does not inadvertently affect our students who have 504s and IEPs. I was planning on voting for this because as a female, I don't want a job because I'm a female. I didn't.
Okay, we get it.
We do live in a racial society. Until you have walked in my shoes, in the shoes of my husband, who's a 25-year vet, my son who have disabilities, my mom, and all the people that came before me, you cannot sit there and the Senate sponsor sit there and tell me that this is needed. Thank you.
So they're going to make their comments, and finally we'll get the vote here.
No further discussion. We have a motion on the floor of due pass on Senate Bill 3. All those in favor say aye. Aye. All those opposed? No. The ayes have it. Congratulations, Representative Bentley. You've passed your bill.
And a little bit of comments on the left.
And with that, we have several bills.
So SB 3 passed. So good bill passed and a bad bill passed today. That's about it, folks. For those who don't know, Jefferson County didn't pass their budget. There's been another shooting in Little Rock. Donald Trump is tearing apart the what is it? The DEI stuff and USA Aid. But that's where we're at now. Well, folks, I got a lot of things to do. Follow me at Just the Right Angle. I decided to make this my 12:35 broadcast. SB 3 will probably clear the House. HB 1204 will probably clear the Senate either today or tomorrow. So insurance companies are going to be able to rip people off, but some of the racial garbage will hopefully be taken out of in terms of hiring practices. So that's where we're at. Remember when the wicked rule, the people groan, and we still have some wicked people. As I understand, Chris Caldwell was in the hearing for SB 1204, and he is the anti-conservative, anti-Christian lobbyist consultant guy, Rhino, who is in Arkansas politics now. And he's pretty much running things in that regard. So we have a long way to go to fix this state and this nation. Y'all have a good day.